of the internet. It is Friday and we've got a lot to attend to, but we can't get started until we can confirm the interwebs are working. And it looks like they are. So that means we can get into it. And hello, my friends. Welcome back to yet another episode of Watching the Watchers Live. My name is Robert Gouveia. I am a criminal defense attorney at the R&R Law Group in Scottsdale, Arizona. And today, Michael Sussmann trial, day 10, wrapped up with closing arguments. And we've got a lot to unpack. We have several different things that we've got to refresh our recollection about. We're going to do that. We'd like to do a brief recap of the mind map so that we understand what we are picking up from, because yesterday we left off in the afternoon on day 9 with jury instructions and stipulations and jury charges and all of that. And of course, then today on day 10, we had closing arguments. And so we're going to break down both of those things, but I wanted to do a quick refresher for those of you who are just joining us. At the conclusion of yesterday's show, we had Brandon Charnov, which was the summary witness over from Latham and Watkins, and he wasn't a particularly compelling witness. Remember, this guy was supposed to come in and summarize all of the evidence for the jurors, and he kind of didn't do a great job on this. When he got asked about this very important date on September 19th, 2016, he said, I don't even know what the heck you're talking about. And really, this was the entire crux of this entire trial. It was about this meeting. And so the prosecutor asked him on cross-examination, are you aware, first of all, do you know that September 19th, he says, is this on this chart that you put together here, Brandon? And he said, no, it's not. September 19th is not on the chart. And he said, you're aware, though, that's the day when Sussmann met with Baker, aren't you? And poor Brandon said, to be honest, this is the first time I'm hearing of this. And the prosecutor was just like, what? This is ridiculous. This is crazy. And so it's kind of an interesting witness to leave with. We had two character witnesses yesterday, Gemma Elliott Stevens and Martha Stansell Gam, who came in and talked about what a great guy Sussmann is. Gemma Elliott Stevens said something along the lines of, after she got divorced, Michael Sussmann took an interest in her son and all of that stuff. And then we had Martha Stansell, who told us that Michael Sussmann actually, really suffered a horrific loss. I don't mean to be jokey about it at all. A father died in a hotel fire when he was like in his early 20s. So we had some interesting character witnesses come out, and it is important that we reference that because the judge explains that he's going to have to make a little bit of an addendum to the jury instructions that we talked about yesterday. And that's a good segue into what we did talk about yesterday, which was, of course, the jury instructions. We recall that we read in several stipulations onto the record, prosecution and the defense. We also saw they had a little bit of a quarrel over whether to include or eliminate that on or about language. We spent a lot of time on that yesterday. And here, yeah, that's not 2022. That is 2016, isn't it? We also talked about this very, very important jury, I think, instruction that made it into the instructions. Here, Judge Cooper introduced this, and I speculated yesterday. I said, if there is a not guilty in this case, it's going to be because of this paragraph. And it says here specifically, Michael Sussmann, he's the defendant. They're explaining to the jurors, ladies and gentlemen of the jury, if you think that, maybe he's guilty, here's what you got to consider. A defendant's conduct is not willful, and therefore he's not culpable for it. He's not guilty of it. If it was the result of good faith understanding that he was acting within the requirements of the law. That's sort of a big, gigantic excuse. That's kind of you can say, well, because, or you call this a fake because people will have one opinion. They'll say, all the facts tell me this, but I'm going to go against those facts because something else gives me justification to do that. Here you see this is a very nice, convenient paragraph. If you're a DC juror, you're somebody who maybe voted or donated to Hillary Clinton, you feel really bad about all of the facts that you just saw, about everything you thought was kind of a hoax, and that your own party was behind it. And so you want to do everything in your power to sort of run away from those hard facts. And you're looking for some sort of justification to satiate your cognitive dissonance that's occurring in your brain. And so you just latch right onto this paragraph and you say, oh, well, it was good faith, wasn't it? Because Putin was the person really responsible for a lot of, really the allegations underlying the original meeting between Sussmann and Baker. Putin and Trump allegedly had this secret collusion affair going on. And Sussmann was only trying to act in good faith to stop that from happening. And so this got written into the jury instructions, and the jurors are going to think about that and read that as they're listening to these closing arguments, which we are about to get to. And so we've got a lot of those closing arguments. Just to give us a quick understanding of what we're about to get into, we see that Jonathan Algor is one of the prosecutors who is pretty active in this case, and he's going to start us off with our closing arguments. He kind of goes out. Remember, the government gets 2 shots at this, which is a total ripoff because they say, the burden of proof. They've got to prove the defendant guilty beyond that reasonable doubt. And so they get 2 cracks at the ball. And then we're going to see that he takes his first opportunity with Algor, and then Berkowitz comes out. He's sort of the main attorney for the defense, and he's definitely the guy to do the closing arguments. They brought on Bosworth to come out and do a lot more of the cross-examination, kind of the good cop, bad cop routine going on. And so Bosworth would come out and kind of slice and dice people, like he rubbed the CEO's nose in that story about him being scared that a man with a gun came to his residence. Remember all of that. But Berkowitz, he's more of the charmer. He's like, oh, judge, gosh, your rulings are just so beautiful and articulate. And gosh, it's like poetry. I've never seen anything quite like this, judge. Outstanding job. Really, bravo. And the judge is like, will you lay off a little bit? But he came out and delivered the closing for the defense, and I sort of was reading through some of the tweet threads earlier today. I haven't taken a look at the transcripts. Normally, I like to peruse the transcripts before we hop on here, but there's just too much to get into. So we'll do it together. But I did, as I was reading through Twitter, kind of in and out of the day, saw that the same themes that we were all speculating were going to come up did in fact come up. So we've got here, you can see Baker, bad memory. Baker doesn't remember what happened at the September 19th meeting. We've got them trying to distinguish between billing errors and billing for a client, while contrasting that with billing while also having a client, right? So it's like billing for a client or billing, but also having a client, not necessarily saying that the two correlate with one another. Also, same themes, FBI screwed this whole thing up. And even if this is all true, it's immaterial. And it's also probably something close to prosecutorial misconduct because of the improper pressure that the Durham prosecutors put on many witnesses in this case. As we heard, many of the witnesses were even under sort of investigation themselves. And so they're going to be saying that these people were colluded or sort of coerced, is a better word, under duress in order to comply with what the special counsel wants. And then DeFilippis comes out and says he's 100% confident, or reminds the jurors that Baker said he was 100% confident that the meeting between Baker and Sussmann included Sussmann saying at that very meeting that he was not there on behalf of a client. So that's sort of the sandwich we get there, the Algor, Berkowitz, DeFilippis sandwich, which sounds terrible, but it's still something that we're going to go through. That was day 10. And so without any further ado, I want to show you the transcript, but there is a little bit more ado because I want to thank a couple of the super chats that came in here today. Starting us off, Patricia Nab and Mary Briggs with 2 very nice transcript donos. And of course, these transcripts cost a pretty penny. They're $1.20 a page, every single page. And I know some people hate me coming on here and talking, thanking you for the donos and things. But like I said, we really could not do this without your donos. And so Patricia Nab said, hello, Rob. Kash Patel said that Sussmann testified to Congress that he went to the FBI on behalf of a client. Did the prosecution enter that testimony as evidence? It seems pretty important. They did. Yeah, so they read that into the record, Patricia. They read all of that in there. The defense came and they added a little bit. They read a little bit of their congressional testimony into the record. So that is all a part of the exhibits and evidence that goes in. And that was a very nice transcript dono to Miss Patricia Nab. And so thank you for enabling us to review these together. The other one that came in is Mary Briggs. Rob, giving you my Friday night beer money for transcripts and skipping a night out with the girls. Thank you, Mary Briggs. It is Friday, and this is a much better place to be. I mean, what's going on out there? It's just debauchery out there. You can get debauchery here, reading court transcripts with me, and it's going to be a lot more fun, I'm sure. And thank you for the transcript dono as well, Mary Briggs. And so if you're watching this on a replay, of course, you can leave a super thanks if you're watching this and can't contribute to the live stream, super chats there, or just like the video. That's also very useful as well. And so, okay, now without any further ado, let's get into it. It is day 10, closing arguments, May 27th, 8:58 a.m. And yesterday, Judge Cooper was very explicit about this. Remember, it's Memorial Day weekend. Many people are probably already on their way to the beaches or to the lake or to wherever people go I'll be here probably reading some more transcripts. But, the judge has places to be. And so he told us all that they were going to be done by like 2:30 at the very latest, because his wife was going to be in the car, in the van, with all of the inner tubes screaming at him, "Get your butt out here." And so he was very serious about this. And he said this even earlier in the week, that if there's a verdict that comes in after the fact, that they're going to have to wait until Tuesday. And he reiterates that here again for us. And so he wanted to keep this thing tight. We get about 140 minutes. An hour 40 each, 100 minutes of closing argument time. And the judge is going to sort of cut off DeFilippis on his second close. So we'll get into it. We see we've got full teams are here ready to go. All 4 prosecutors, all 4 defense lawyers. Lisa, our AM court reporter, is in the house. And there's a little bit of the character evidence argument, some of that jury instruction issue that we talked about previously. And the judge says, "Good morning, everybody. Now, before we bring the jury in, got a little note here that the defense said that they want some additional jury instructions on character evidence." And we talked about this yesterday because we listened to these 2 individuals come in and kind of tell us that they've known Sussmann, they think he's a truthful guy, and that he would never do anything so bad and so problematic. But they didn't give the jurors instructions about what to do with those people. Remember, the judge already told us that there's kind of 3 different types of witnesses: lay witnesses, expert witnesses. And then he told them again, oh, there's also character witnesses. I forgot to tell you about them. But they didn't go into the jury instructions because they very rarely use these types of witnesses in these criminal trials. And so the judge says, look, the defense brought this up. They were reviewing these yesterday and they didn't see it in there. And they said the prosecution, however, objected to that instruction going in, saying, no, you already had your opportunity on this. And remember, there's some truth to this. Remember when the prosecutor, I think it was DeFilippis, wanted to impeach Laura Sego, I think she was with Fusion GPS, and the judge said, sorry, you didn't bring it up. I mean, you're out of time. She's not on the bench anymore. She's been excused, released from her subpoena, and she's gone. You lose your argument. Sorry. Here, the prosecution is making that same argument. They're saying, Judge, we approved these jury instructions yesterday. There's no character evidence in there, no character instructions. We don't need to call special attention to this character person. The prosecution doesn't want the jurors to go back there and say, oh yeah, that lady said that Michael Sussmann took very good care of her kids, or that he's a very nice man who would be always, be honest, and he had a family tragedy back 80 years ago. None of that stuff, the prosecution, they don't want the jurors to keep that front and center. So they want to bury this. The defense, by contrast, wants to be like, oh yeah, this is very important. It should probably be in bold letters. Like, this character evidence is more important than anything else you heard. Forget about what James Baker said. Listen to what this little old lady said. She's retired for the last 14 years. She's much more charismatic and convincing than James Baker, right? Forget all that. And so they're going to fight over this for a bit. Now, the judge says government raised the objection, saying that this is a timeliness is a problem, and saying that they don't want to add more highlighting of this instruction. Now, if the jurors hear this, they're going to be just sitting there going, well, that's weird. Why is he specifically talking about character witness now? We got to add this new instruction. Is that instruction more important than the other instructions? Because, and you have to think about this. In law school, they teach you about, and many other domains, they teach you about primacy and recency. The things that hit you first and the things that hit you last are the things that stick out the most. The stuff that kind of happens in the middle, you're just kind of like, whatever. That's why movies have, the big booming opening entrance and the big climactic ending. Whereas the stuff in the middle, you're like, oh, they're romantic now. They're like dating now. Who cares? Whatever. It's primacy. What hits you first? Recency. What hits you last? And so if the jurors are sitting there and they're like, oh, all this is new character evidence instructions, I guess we better pay a lot of attention to it because it's recent. So the judge says, I'm inclined to give the instruction. He says, I think it would be helpful to the jury. I mean, they're going to wonder what they're going to do with this character evidence, which is true. Unfortunately, he says, it wasn't read to them initially, but I think the court has an independent obligation to make sure the jury knows how to consider the evidence in this case. Had we left out, the reasonable doubt instruction, obviously I would include that despite the fact that it wasn't raised in the charging conference, which is what we had yesterday, or in the initial proposed instructions. It says, the judge is explaining this to the prosecutor. He kind of knows he's screwed up. He knows the prosecutor actually has some merit to this complaint. You left this out. Very important. But you left it out. Sorry, you lose the opportunity to do that. Defense, you should have objected yesterday. So the judge says, okay, I know it kind of screwed it up and we're about to do closings and all this. So he says, I'll tell you what, Mr. Prosecutor. I will, I'm going to soft pedal it, okay, to the extent that I can. And I'm going to instruct them again that they should not focus on any one instruction over the others. I'll iterate that standard instruction that we gave. And so he says, okay. And the prosecutor's like, again. So the judge says, Mr. DeFilippis, would you prefer that I give it now, or should I wait until after closings and just include it in the court's, sort of like pre-deliberation instructions? And the prosecutor says, no, let's get it out of the way now. We want it more in the middle. We don't want it to be ultra recent. We want to shove it in the middle. He says, okay, yes, Your Honor. We'd ask that you do it now and that you preface it with some kind of a statement, that it was an oversight, that, something like that. All right. Judge says, okay. And who's going to do the initial close? And the DeFilippis says, that's going to be Mr. Algor over here. He says, all right, so bring in the juries. Jury comes in. Judge says, okay, listen, I kind of botched it yesterday. Says, good evening, ladies and gentlemen. Good to see you. Before we get started with closing arguments, you will recall that you heard from two character witnesses on Wednesday. It has been brought to my attention that I neglected, so he's sort of accommodating the prosecutor, that I neglected to give you an instruction on how you may consider that character evidence, so I will instruct you as follows. The defendant introduced testimony saying that he has good character for truthfulness and honesty, saying evidence may indicate that it is unlikely that a true and honest person would commit a crime. And he gives him the standard instruction and says, this instruction is going to be included, just like I told you yesterday. All right. And then the government's going to proceed with its closing argument. So, they'll read that. The transcript, of course, is available. But he just says, after weighing all of this evidence, if you're convinced beyond a reasonable doubt, it's still your duty to find him guilty. He says, evidence of character alone may create a reasonable doubt as to the defendant's guilt, although without it, the other evidence would be convincing. So it is kind of a, notwithstanding the evidence, if after weighing all of the evidence, you are convinced beyond a reasonable doubt that he is guilty, it's still your duty to find him guilty. You may consider this evidence along with other evidence and give it as much weight as you think it deserves. Such evidence may indicate to you that it is unlikely that a truthful or honest person would commit a crime charged, or it may not. So it's basically sort of telling them that they can use it or lose it, give it as much weight as they want to or not, but it's still, jury instructions are it's like 60 pages in many of these cases. And so jurors just flip through it and they just latch on to what they want to. And this is that same conversation that we had at the start of the show about the fake because and about latching on to any part of the instructions that are going to justify your preconceived verdict. You want an outcome and you have to find the road to get there. And you just go through the jury instructions. Oh, good faith argument here. And here we've got character evidence here. And I'm just going to pick this one and come to my own conclusion, which is why I think it's going to be hard to convince, some of these highly politicized jurors that this is a guilty verdict, but we will see. So anyways, they say we're going to start up with the closing arguments, and the judge gets that all aside, gives them their instruction. And the prosecutor, Mr. Algor, steps right up. And again, this is closing arguments. We're on day 10 of this baby. And he says, good morning, ladies and gentlemen of the jury. The evidence has proved beyond a reasonable doubt that the defendant, Michael Sussmann, made a false statement to the FBI General Counsel, Jim Baker, on September 19, 2016. On that day, the defendant used his privilege as a high-powered Washington lawyer, former DOJ prosecutor, and a friend of the defendant to bypass normal channels and to expedite a meeting with the FBI General Counsel. And in that meeting, the defendant made a false statement when he told Baker that he was not there on behalf of any client, that instead he was there as a good citizen, bringing it on his own. And why did the defendant do this? Because he knew he had to conceal his representation of the Clinton campaign and Rodney Jaffe to be able to push this Alpha Bank allegation to the FBI. He knew that if he told Mr. Baker that he was there on behalf of the Clintons, the chances of the FBI investigation would be diminished, would be seriously less, that Mr. Baker might not even take the meeting. And he knew that his other client, Rodney Jaffe, did not want the FBI to know about his role in the allegations. The defendant knew that he had to hide his clients if there was any chance of getting the allegation into the FBI. And that, ladies and gentlemen, is why the defendant lied. Got a little bit of motive there. Now, ladies and gentlemen, in this summation, I'm going to do three things. First, I'm going to briefly explain the charge as Judge Cooper instructed you yesterday, and I ask that you keep it in mind as we go through the summation today. And second, I'll discuss the evidence that has been shown in this case and address only two questions that I think will be before you. whether the defendant lied and whether the lie was material to the FBI. And throughout the summation, I will cover in detail the defendant's false statement and how it was material to the FBI. But let me just briefly discuss with you the evidence on each of these points because it is overwhelming. You have the billing records showing the defendant billing his work day in and day out to the Clinton campaign. Day after day, the defendant continued to bill his work to Hillary for America. And then there's also the defendant's own words. The lie in his text message on September 18th, which he then repeated as a false statement to Mr. Baker the next day on September 19th. And you also saw his congressional testimony in December 2017, where he admits that he was representing a client when he met with Mr. Baker on that day. And we all knew and know who the client was, Rodney Joffe. And within that testimony, he also concealed the fact that he was representing the Clinton campaign during that meeting. Prosecutor says, what else do you have? Says, you have thumb drives, the ones he provided to the FBI. And who did he bill? The Clinton campaign. What else? You have the defendant's actions as he pushed the Alpha Bank allegations to the FBI and then subsequently pushed it to the media. He continued to promote all the allegations to the press, both before his meeting and after. It wasn't about national security. It was about promoting opposition research against the opposition candidate, Donald Trump. And what else do you have? You have the defendant's same lie to the CIA less than 6 months later. You'll also see the testimony of the FBI's witnesses about how it was material to the FBI in conducting the functions of the FBI. Finally, ladies and gentlemen, after talking to you all about the evidence of the defendant's false statement and how that was material to the FBI, I'll explain why the evidence proves beyond a reasonable doubt that the defendant is guilty. So as I said, I'm going to explain the charge. The defendant is charged with making a false statement to the FBI. Now, yesterday, Judge Cooper instructed you on the law. He is the sole authority of the law. Whatever he says controls. You're going to have the jury instructions. And as you heard yesterday, Cooper told you that the government is required to prove this beyond a reasonable doubt. So he says, let's look at the elements here. First, you have the defendant made a statement or a representation. Element number one. He says this element is met by showing the defendant made a statement, which in this case was the statement to Baker on the 19th. Checkbox. The next element is that the statement was false, fictitious, or fraudulent. That is the evidence which shows that the statement in question was untrue when it was made, that the defendant knew it would be untrue when he said it. With respect to materiality, it is simply whether the defendant's statement had a natural tendency or was capable of influencing the function of the FBI. Now, ladies and gentlemen, as Judge Cooper instructed you, the government is not required to prove that this statement actually influenced the FBI, only that the statement could have influenced the FBI. The next element, knowing and willful conduct. That is the evidence which shows that the defendant meant to make the statement and did so knowing, as a former Department of Justice prosecutor, as a lawyer, that it was wrong. And last, there's this reference to federal jurisdiction. You've heard that part of a stipulation that the FBI is part of the executive branch. So let's turn to what happened. As I said, I'll review some of the evidence. I encourage you to review it as well. Take a look at the text message to Mr. Baker on September 18th. Review Jim Baker's testimony. Read all of the defendant's billing records to Hillary for America during this time. Look at the testimony of Jim Baker and various other FBI employees as they discussed all the ways that it could have impacted the FBI when the defendant made the false statement back on September 19th. All that evidence, says the prosecutor, will be available to you. So let's start with what's not in dispute, says Mr. Algor. The first element, statement or representation. There is no dispute that the defendant made a statement to Jim Baker on September 19th. The evidence on this element is overwhelming. You've heard that through Baker's testimony. You've seen it through Bill Priestep's notes. You've looked at Tricia Anderson's notes. That element is met. Don't even need to think about it. But what about the other element? A matter within the jurisdiction of the United States government. That's the one I just discussed, the fifth element that the parties stipulated to. Don't have to discuss that one either. So let's talk about what is in dispute, says the prosecutor. So how do you know that the defendant's statement to Jim Baker was false? He says this is the element. False, fictitious, or fraudulent. It's shown through his billing records, through his coordination with Fusion GPS and others to push the allegations to the FBI. It's shown through his own words, his own actions, and his own testimony. Let's start with the clients. We saw some early evidence regarding contracts that Perkins Coie and Fusion GPS entered into. We have an engagement letter with Hillary for America. You recall testimony from Mark Elias, Robbie Mook about this, and Perkins Coie represented Hillary in 2016. We look at Fusion GPS. You learn that Fusion was a research consulting firm hired by Perkins Coie, the law firm, to provide opposition research for the Clinton campaign to focus on research about Trump and ties to Russia. That's Exhibit 302. We also talked about Rodney Jaffe. This is the engagement letter showing that Sussmann represented him personally. And Mr. Sussmann also represented Jaffe's company, Newstar. You heard testimony about that. And let's look at origins of Alpha Bank's allegations. You heard a lot about these, that there was an alleged secret covert communication channel between Trump and Russia, known as Alpha Bank. But where does this story all begin? Well, you heard about testimony that in the summer of 2016, the defendant, Fusion GPS, Rodney Jaffe, were all working on the Alpha Bank allegations. And we start back in July 2016, July 29th. Now, ladies and gentlemen, there are a lot of exhibits in this case, and I'll try to mention them to you as I describe them. But as you can see from the bottom of each slide, it makes reference to the exhibits if you need them for your own benefit. So it sounds like what he's created here is like a little bit of an index. So he'll give them an index, essentially. He's walking through the slides reference the exhibit. In other words, if you want to take a look at this slide, what's on this slide, exhibit is, 305, it's marked, go pull that exhibit up. And we're not going to go through, 90 minutes of exhibits, but let's see what we can tease out of here. It says, so we'll start with the defendant emailing Mark Elias's assistant, confirming that he's going to be attending a meeting with Mark and Fusion. That's 306. And you'll see here, we've got a calendar entry. It's a 30-minute meeting, and it's in the Clinton campaign category. On July 29th, who does the defendant bill his time to for that 30-minute meeting? Hillary for America, 5.3 hours, client number whatever. And how does he describe his time? Quote, meeting with M. Elias, others regarding a confidential project. And that was back in July. Now, ladies and gentlemen, you will see that the defendant's billing entries are sometimes vague and they're sometimes precise. But I submit to you, have seen indisputable evidence that the defendant was billing his work on the Alpha matter to Hillary for America. Your common sense can tell you that. So let's turn to 2 days later, July 31st. This is another entry. And here it says it's also billed to the Clinton campaign. It says, quote, communication with Mark Elias regarding the server issue. The server issue is the Alpha Bank issue, is what the prosecutor is explaining to the jury. Fast forward to August 11th. We see emails between Sussmann and Mark Elias, his partner and a top Clinton lawyer, Glenn Simpson and Peter Fritsch. Now, ladies and gentlemen, you heard testimony from these individuals, about these individuals, how Glenn Simpson and Peter Fritsch were the co-founders at Fusion. And what happened the next day? The defendant met with Fusion and Mark. And who else? Rodney Jaffe, his client. And who did he bill for those meetings, ladies and gentlemen? Clinton campaign, 1.5 hours, quote, confidential meetings with Mark Elias and others. The others? Well, that was Fusion GPS and Rodney Jaffe. That's Exhibit 553. Fast forward a few days, August 15th, and around this time, Jaffe was tasking his employees to use cybersecurity resources to conduct opposition research. You heard testimony from Steve DeJong, who worked at Newstar, who was pulling data for Jaffe. You heard from Jared Novick, the CEO of Bitvoyant. He received a tasking from Jaffe, and he was saying it was extremely uncommon because it was asking him to look for research and data related to Donald Trump. Now, if you recall, Bitvoyant's mission was to do security for companies, not individual research. And you were also able to see that the opposition research that Bitvoyant did for Jaffe, and that government exhibit is 1200. It's there on the screen. This is research that includes references to Alpha Bank. It points to related domains. It points to the Tor and Trump email addresses. Ladies and gentlemen, I submit that this is evidence which shows the defendant is leveraging his client, Rodney Jaffe, to benefit his other client, the Clinton campaign. This is not cybersecurity work. This is nothing related to national security. This is pure opposition research. Sussmann's bringing two people together to use them against a common enemy. At that same day, the defendant in his communications, prosecutor asks the jurors, who is he communicating with? Fusion GPS, the Clinton campaign's research firm. 2 days later, on August 17th, we see a calendar entry, another 30-minute call on this day. The subject, telephone conference regarding a status. And when we see the location, we see the quote, Michael and Mark will call Rodney. The defendant, Michael Sussmann, and Mark Elias will call Rodney Jaffe, the defendant's client. And it says that the defendant, and how does the defendant bill this call? Well, you see that at our exhibit here, a half-hour telephone call with Rodney Jaffe and Mark Elias. Who is that bill going to? The Clinton campaign. And then you have Mark's testimony, how he had no other reason to interact with Jaffe other than related to these allegations. Why would Jaffe, a cybersecurity person, need to interact with a political lawyer, with the head lawyer of the Clinton campaign? Not for a national security concern, but for opposition research. 2 days later, on August 19th, once again, we have another meeting between Mark and Jaffe. You see telephone calls between Sussmann and Jaffe. That's multiple emails back and forth between the two. And again, ladies and gentlemen, who does the defendant bill all this time to? The Clinton campaign. 3.3 hours, quote, confidential meeting with M. Elias and others. And you also see, quote, work on the document. Algor says, I submit that this defendant, and this shows this defendant, starting to bill his time to the Clinton campaign as he starts work on one of the white papers that will eventually give to the FBI. 10 days later, we go to August 29th. And remember, we're working our way up to September 19th, which is that big date. And let's put ourselves back in context here. The election is in November. So we've got August, September, October, November. We're creeping up here, and the prosecutor's just assembling the timeline for the jurors. 10 days later, August 29th, the defendant sends Jaffe an email with the subject key. That's Government Exhibit 342. Ladies and gentlemen, I want you to remember this exhibit as I make reference to it later. Key. And what does the defendant bill to today? He bills again to the Clinton campaign, 2.3 hours. August 30th, we see another email. Peter Fritsch sends this over, copying Glenn Simpson. These are members of Fusion GPS. Subject, you will see the whole and what this needs. What's the attachment? As these guys are plotting, the document name is Alpha Group Overview.docx. Now, ladies and gentlemen, you'll recall that one of the white papers that went to the FBI involved Alpha Group Overview. You recall seeing that. This is Fusion GPS, the Clinton campaign's research firm, drafting a white paper eventually ends up at the FBI. We've got another exhibit. This is the defendant communicating on this day, his client, Rodney Jaffe, also communicating with a New York Times reporter. That's Government Exhibit 349. We see Mr. Lichtblau, who works at the New York Times as a journalist, saying, I'm back in town. I see the Russians are still hacking away. Any big news? Prosecutor says, ladies and gentlemen, this is August 30th. If the defendant and Rodney Jaffe are so concerned about national security, would there be a priority to meet with the media or to flag this for the FBI? And what is the defendant's priority here? The media promoting this. And who is he promoting this on behalf of? The Clinton campaign. What else do we see on this day? Exhibit 350. Defendants emailing and coordinating with Fusion GPS and Mark Elias, the Clinton campaign's top lawyer and the research firm. And how does he bill his time for this day? 1.5 hours. Quote, communications and work regarding confidential project. This is from Perkins Coie own records. Exhibit 553. Now, ladies and gentlemen, I'll submit that Government 602 says it all. This email speaks 1,000 words about how this was pure opposition research and that the defendant was representing Rodney Jaffe and the Clinton campaign when he put together the Alpha Bank allegations. An email with the defendant, Rodney Jaffe and Laura Sego, a Fusion GPS employee who was working on research for the Clinton campaign. And what is the subject? Quote, privileged client, attorney communication, New York 1. Prosecutor says that says it all. So what happens the next day? The defendant continues to communicate with Fusion and Jaffe. Excuse me, he says, what does this show? This is a government exhibit on August 31st. And what do we see here? He says, this is Fusion GPS continuing to work on the Alpha Group Overview white paper, the one that would go to the FBI, the Clinton campaign's research firm working on material that would be promoted by the defendant to the FBI. And how does he bill his time? Clinton campaign. On that day, communications regarding confidential project, 1 hour. Turning over to the next day, Prosecutor says, again, the defendant is conducting multiple meetings with Jaffe, Fusion GPS, as others as he works to promote these Alpha Bank allegations. 356 says there's a calendar entry regarding holding a confidential meeting. And who is the defendant meeting with later in the day? New York Times, Lichtblau. We also see Lichtblau wanted to set up a meeting talking about now Sussmann bills that time about that meeting, confidential meetings regarding confidential project, bills it to Clinton campaign. A few days later, we have another one, September 5th. The defendant works on the campaign, submits a billing entry for Clinton. He's meeting with Fusion GPS. We have another exhibit, all about communications with his client, Rodney Jaffe, opposition research, and Alpha Bank. Again, he bills the time 8.1 hours, meeting in McLean, Virginia, working on the white paper. This white paper is eventually going to go to the FBI. September 6th, we see a calendar entry, Fusion Sussmann meeting with Mark. You heard testimony from Laura Seago about her interactions with Jaffe and the defendant. Seago testified that she participated in a meeting on behalf of Fusion, which included other Fusion members. You heard Seago's testimony. She mentioned she was there with Sussmann and Rodney. What was the purpose of that meeting? To discuss allegations and communications between Trump and Alpha. We also see on September 6th, the defendant again spent a considerable amount of time working on it. And he billed his time, ladies and gentlemen, to the Clinton campaign. You see here 4.4 hours, quote, meeting with consultant Mark Elias. Next day, the defendant continued his work. Another exhibit. What do we see here? Quote, work on written materials. They go forward to September 8th, less than 2 weeks before the meeting with Jim Baker, which took place on the 19th. Defendant still had not talked to the FBI about the allegations. There is no national security concern, is what the prosecutor says. Been going on since July, right? They've been working on this for months now. Still no national security concern. They haven't even met yet. But what's he doing? He is calling his client Rodney. That's Government Exhibit 371. He's also conducting confidential meetings. That's an hour and a half. That's Government Exhibit 372. And who's he calling now that all of this is a big, grave national security concern? Eric Lichtblau, New York Times reporter. Prosecutor says no national security concern. He's willing to meet with the press, though. He's willing to meet with the press so that he can benefit his client, the Clinton campaign, and push the opposition research and the Alpha Bank allegations. And how does the defendant bill for his time on that day? He says, quote, AM and PM confidential meetings, telephone conferences, preparing materials, 4.5 hours, over half his day spent on the Clinton campaign and the Alpha Bank allegations. A few days later, we go to September 12th. What is he doing? Having calls on behalf of the Clinton campaign. Talking to Mark Elias and Eric Lichtblau. You see in that day, Mr. Elias's email for his billing entry, and the phone records show that he was in fact calling Eric. 2.7 hours. Ladies and gentlemen, we go to September 13th. What are these? It's a receipt from Staples for the thumb drives. That's Government Exhibit 380. A receipt from the Staples that's just down the street. And I want you to focus your attention on the highlighted portion of that receipt, ladies and gentlemen. It says, quote, PNY 2-pack, 16 gigabytes. That's referenced on the receipt. And I want you to remember that. And so does the defendant meet with anyone else on that day? It says our meeting, his client, Rodney Jaffe, hour and a half. Turning to the next day, who did he meet with again? His client, Rodney Jaffe. That's Government Exhibit 382, hour and a half meeting, and he billed that day to the Clinton campaign. Multiple meetings regarding the confidential project. Again, drafting a white paper. Further meetings and telephone conferences. Meeting with Mark, the Clinton campaign's top lawyer. That's another exhibit. What else is he doing? He's emailing Eric Lichtblau, talking about the confidential project, 5 hours there. 2 days later, prosecutor says, I submit that based on the testimony you've heard that September 17th was a Saturday. You learn that Mr. Baker, general counsel at the FBI, received a text message on Sunday night, September 18th. And you see here in government exhibits that the defendant had a 20-minute phone call with David Dagon. Now, ladies and gentlemen, you heard testimony about Dagon. He's a cyber expert and one of the authors of the white paper. And how did he bill his time for that? 4.8 hours, multiple telephone conferences with experts, media, communications, and Mark Elias. And then we get to the defendant's false statement, and it starts on September 18th. Now, you've seen this message, which was sent by the defendant at 7:24 p.m. Quote, Jim, it's Michael Sussmann. I have something time sensitive, parentheses, and sensitive, I need to discuss. Do you have availability for a short meeting tomorrow? I'm coming on my own, not on behalf of a client or company. Want to help the Bureau. Thanks. Ladies and gentlemen, the defendant used 42 words in that text message, and 20 words of them was a lie. And how did the defendant bill his time for that? 5.5 hours on Sunday, further communications and work regarding a confidential project. And who did he bill it to? The Clinton campaign. Now, what is the truthful statement here in the prior text message? The truthful statement is, I'm coming on behalf of the Clinton campaign, my client. The truthful statement is, I'm coming on behalf of Rodney Jaffe, my client. The truth is, I promoted these allegations to the New York Times. But you don't see that in the defendant's text message here. And so we fast forward to September 19th, the next day, the meeting with Jim Baker. A 30-minute meeting that was held at FBI headquarters here in D.C., and there's a calendar entry in an exhibit. You learn from Jim Baker's testimony that the defendant repeated his lie as a false statement to Jim Baker on the 19th. You saw that Jim Baker said that Mr. Sussmann told him, quote, I'm not here on behalf of any particular client, in his meeting on September 19th. And when asked how confident Mr. Baker was regarding the defendant and whether he made that statement, he said, quote, I'm 100% confident that he said that in the meeting. Again, ladies and gentlemen, what would have been the truthful statement in that meeting? That the defendant was there on behalf of the Clinton campaign. That the defendant had provided these allegations to the New York Times. That the defendant was there on behalf of Rodney Jaffe. And how do we know that Jim Baker's testimony is right and credible? Well, we've got the notes from Bill. He said on the 19th that said, quote, not doing this for any clients. He wrote those notes after speaking with Baker. He wrote down what Baker told him that Sussmann said during the meeting. And how do we know? Well, we see Tricia Anderson's notes as well. Sussmann meeting with Baker, no specific client. They're going to look at those notes as exhibits back in the jury. And when did Miss Anderson take those notes? When did she write that down? September 19th. Now, ladies and gentlemen, now we see how the defendant bills his time. And so you've heard the defense make arguments about how the defendant was working for the Clinton campaign on the Alpha allegations, and he was working for Jaffe as well. And that up until September 19th at 2 p.m., he was representing the Clinton campaign and Rodney Jaffe. But then when he went to that meeting, he stepped out of those roles. He was no longer representing Clinton or Jaffe. Instead, he was there as just a good citizen. But look at how the defendant bills his time less than 12 hours after the meeting with Mr. Baker. Time, Monday, 9/19. And who is the defendant sending it to? Lee Nichols. This is the government exhibit 402. Work on written materials, in other words, the white paper. Other work and multiple teleconferences, 4.5 hours. We have another bill. Work and communications regarding confidential project. How did that happen? You'll see that on September 20th, what the defendant was thinking about when he was representing that day. You now have an email from November 6, 2016. Time, Monday, September 19th. The defendant is sending this to his assistant, Leah. It says, quote, HFA, work and comms regarding confidential project. That's exhibit. This defendant is covering his meeting with Mr. Baker, his representation of the Clinton campaign and Rodney Jaffe, when he changed that time entry 2 months later. Wow. What else do we know about how the defendant was representing the Clinton campaign in that meeting? We see it in the reimbursements for the thumb drives that I mentioned earlier on September 13th. Who is the defendant billing those thumb drives for? Hillary for America. What does it say? Purchase of new single-use flash drives for secure sharing of files. And what is the expense report? Goes to the Clinton campaign. Purchase of new single-use flash drives. Prosecutor Algor says, who did the defendant think he was going on behalf of when he was bringing the thumb drives to the FBI? The Clinton campaign. He brought those two thumb drives, those PNY 16 gigabyte red and blue thumb drives. You saw those. That's government exhibit number 1. And you can look back at exhibit 380, the Staples receipt, and when you can look at the highlights that we put on there, PNY 2-pack, 16 gigabytes. Who did the defendant think he was representing in that meeting on the 19th? I submit that this shows the defendant was representing the Clinton campaign. So how else do we know that the defendant's false statement was a lie on September 19th? We see it also in the defendant's meeting with the CIA. You heard testimony from two CIA employees. First, you had Mark Chattison. You might recall him. He said he wanted a meeting. Defendant told Mr. Chattison that he wanted a meeting on behalf of a client. But what did the defendant do? What did Sussmann do? Once he actually was able to obtain the meeting, he lied again to the CIA. You saw that from another exhibit. There's a memorandum between Kevin P. and Steve M. They wrote it with Sussmann. We also know the defendant made a false statement to Baker on the 19th. How? Through his own words. You may recall some of the excerpts read to you from the defendant's testimony when he was in front of Congress back in December 2017. We got those admitted in as exhibits. He was specifically asked about his attorney-client relationships and what happened when he went to the FBI and the CIA. And what did he do when he was asked about this? He admitted what he couldn't deny, but denied what he couldn't admit. He said, quote, "I think it's most accurate to say it was done on behalf of my client." And who was that client? Well, he had never actually provided the name. He referred to them as anonymous client. But ladies and gentlemen, we all know who that client is. It's Rodney Jaffe. Now, Mr. Sussmann was also asked by Congress about Fusion. What did he say? Fusion was not my client, but he concealed his relationship with Fusion GPS regarding the Alpha Bank allegations. Not once does he disclose that he worked with Fusion, that one of the white papers that he went to the FBI with was drafted by Fusion, nor does he tell Congress about his other client. He makes no mention that he was representing the Clinton campaign for Alpha Bank allegations, that he was billing his time to the Clinton campaign day after day. So now we turn back to September 21st, a few days after the meeting with Sussmann and Baker. What is Mr. Sussmann doing? Well, he's calling Mark Elias, the Clinton campaign's top lawyer. He's calling Eric Lichtblau, New York Times reporter. He's calling Jim Baker. And you remember testimony regarding this? Jim Baker wanted to know what reporter was working on the Alpha Bank allegations. And ladies and gentlemen, you may recall that the defense has tried to argue the defendant was concerned with national security, that he wanted to give a heads up to the FBI. But in that meeting with Baker on September 19th, he never disclosed who he was working for from the press. He never disclosed all of his communications with Lichtblau. He only waited until a few days after he had gotten the material into the FBI to disclose the New York Times was working on the story. Who else is he talking to? Says he's client, Rodney Jaffe. We saw following his meeting with the FBI, Sussmann and Fusion continued to push the Alpha allegations into the press. September 27th, government exhibit. I referenced previously key between the defendant and the email between Rodney Jaffe and Sussmann. And what's the defendant doing here? He's providing that key regarding how to read and review the DNS data. And what else is he doing? He's now back again representing the Clinton campaign and Rodney Jaffe, no longer a good citizen, but promoting the Alpha Bank allegations to the press. Billed September 27th, 3.9 hours, quote, working on a confidential project. And what else is going on at this time? Well, we see emails and communications from Fusion, the Clinton campaign, their opposition research firm, promoting this to the press. Somebody named Mark sends an email to somebody in the media. 2 weeks later, Fusion GPS again promotes it to another reporter. October 31st, now, ladies and gentlemen, you heard testimony about, quote, an October surprise. Whether it's mythological or not, this is an article. These are articles that come out less than 2 weeks before a presidential election. These were built up opposition research paid for by the Clinton campaign, and we see that it's now being actually promoted to those reporters by Fusion. We learned a bit about the articles that were published on that day from Eric Lichtblau, who was talking with Mr. Sussmann repeatedly, also talking with Franklin Foer, another article journalist person from Slate. And we see Mr. Sussmann on that day working for the Clinton campaign, communicating with Eric Lichtblau. He's also promoting it to other reporters, to Nancy Cordes of CBS News. And we see the promotion of these articles by the Clinton campaign themselves. This is Government Exhibit 52. We saw the tweet from Secretary Clinton and the press release from Jake Sullivan regarding the Alpha Bank allegations, the work that the defendant and Rodney Jaffe and Fusion GPS had been doing since July 29th, coming to fruition, pushing an article and pushing it to the press on October surprise. When? October 31st, 2016. And how does the defendant bill his time? communications regarding the Slate story, New York Times reporting, and communications with CBS. Now let's turn to the next element, the false statement being material to the FBI. And before we get into the various ways that it was material to the FBI, I want to remind you again of Judge Cooper's instructions. The defendant's false statement is material if it was capable of influencing the FBI and its decisions and functions. That's it. You do not have to spend time thinking about how it did impact the FBI, just how it could have influenced the FBI. The government does not have to prove the FBI actually relied on the defendant's false statement. So we start with the FBI's investigation, and we see the white papers the defendant and Fusion GPS drafted and provided to the FBI. Those are in evidence. And you recall the findings in the white paper that Sussmann worked on and billed to the Clinton campaign. And that final paragraph, quote, the only plausible explanation for this server is that it shows Trump Organization and Alpha using multiple sophisticated layers of protection in order to obfuscate their considerable recent email traffic. And you'll also see the Alpha Group overview. You've heard references and research to evidence being prepared by Jared Novick, Richard Burt, and others. You heard the FBI's ultimate conclusion about all of this from Scott Hellman. Question, Scott, and what did your analysis generally speaking find? Quote, we did not agree with conclusions in the paper. We did not agree that this data represented the findings of a secret channel of communications. You also saw testimony from Allison Sands that there is no evidence of U.S. companies from all the things they had done, from talking to U.S. companies, Listrack, Sinden, talking to Mandiant. There was no evidence that this covert communication channel existed. You also heard from Agent Heidi, said, quote, we were not able to substantiate any of the allegations in the white paper, the opposition research that Clinton paid for that the defendant brought to the FBI. So how is this material to the FBI? So we know the defendant's false. So how do we know the defendant's false statements were material? Asks the prosecutor. Well, you saw the defendant's text the night before meeting with Jim Baker, and it's the same lie that he told Baker the next day. And how do you know that it mattered? Because Jim Baker said that he might not have even taken the meeting if he had known the defendant was representing Clinton when he brought the allegation to him. And how else did it matter? It mattered because the defendant hid his client's political affiliations, his business interests, and the fact that one of them was a confidential human source. And so we look at Mr. Baker's testimony, and ladies and gentlemen, I submit that Mr. Baker's testimony alone proves the materiality element here. He made multiple references to all different things that he would have done and would have known if he would have known that Sussmann was representing Clinton and Rodney on the 19th. He would have paused the investigation. He would have consulted with the front office about whether to even go forward with the investigation. He would have had others participate in that meeting. He would have had consideration for this being literally a month and a half before a presidential election. So let's talk about the ways it was material and how the defendant's political affiliation impacted the meeting. If an opponent brought this information, we heard this from Baker, he said if an opponent brought this, they would want to know more about it. They would question the credibility. We also heard from Allison Sands saying if it was politically affiliated, they would have wanted to know about the motivation. Agent Heidi was in here saying that timing would have been a very big concern for him. And what about the defendant's client's business interests? The defendant's false statement was material because it hid the business interests of Jaffe, someone who profited off the FBI and the intelligence community through lucrative contracts worth tens of millions of dollars. But Jaffe wasn't even willing to show his face. So how could the defendant's concealment of Rodney Jaffe have been material to the FBI? Well, you heard it would raise alarm bells if a guy who had lucrative contracts with the FBI was unwilling to give this to the FBI under his own name and his own relationship. Rodney was interfacing with the government, but couldn't even go through his own channels to say, I found a threat. You also saw, or maybe he was just embarrassed by the threat, or he knew it wasn't actually a threat. And you saw that through the testimony of Scott Hellman. You also saw it through the testimony of Agent Heidi and how one would want to know whether the person had a financial benefit of bringing the info. And wouldn't you want to know if this person was a CHS, a confidential human source? You heard about circular reporting and how this could be a problem. We talked about Tom Grasso and Mr. Jaffe. We heard from Allison Sands. They'd want to know about the motivation and the credibility of the confidential human source. And there's concerns about why Jaffe needed to conceal his connections to all of this. So, ladies and gentlemen, I now want to walk you back through the elements. And we've addressed many of these. The statement, it was false, it was material, and the matter was within the federal jurisdiction of the government. So I want to finish with knowing and willful conduct. Now, I expect the defense is going to stand up here today, and they're going to try to convince you that this was a misunderstanding, that Michael Sussmann was acting in good faith when he brought the allegations to the FBI. And when they make that argument to you, I want you to use your common sense. I want you to remember that text message that he sent to Baker on September 18th. You can see that at the bottom left. He says, not on behalf of a client. And you remember Mr. Baker's testimony that he was 100% certain that the defendant stated the same thing in his meeting on September 19th. And you remember seeing this through Mr. Priestep's notes, which said, quote, not doing this for any client. And you remember the defendant's own testimony in front of Congress, his admission to the lie. When you look at all the evidence, is the defendant's statement that he was not acting on behalf of a client the truth? No. A person acting in good faith, a person who knows the law, would not say and do the things that Mr. Sussmann did on the 19th. The fact that Sussmann said that he was not there on behalf of a client shows you exactly what was in his head all along. Ladies and gentlemen, when you take a look at all the evidence, the defendant's own words and the defendant's own actions, it is overwhelming. The evidence has proven beyond a reasonable doubt that Michael Sussmann made a false statement to the FBI on September 19, 2016. You should return the only verdict supported by the evidence in this case. Guilty. Thank you. Thank you, Mr. Algor, says the court. Ladies and gentlemen, we're going to take a brief 10-minute break, and we're going to allow the defense to get ready to deliver its summation. And we're going to take a parchment break so we don't get parched or turn into parchment. So no discussions about the case. No research about the case. Jury exits the courtroom. Whoa! So that was Jonathan Algor's opening statement there. Not too bad there, Jonathan. I liked it. It was pretty mechanical, but I think very, very useful, very necessary. And I also agree with him. I think it's pretty dang overwhelming. All right, so cheers to the water break, everybody. Cheers to the water break. We've got still some heavy lifting to do. I mean, remember, the defense is going to use a lot more time. The prosecution, we just kind of split. We're kind of like halfway through the prosecution. So the defense is going to be a little bit longer, and we're likely going to skip over some of the heavy lifting that they do, but we definitely want to make sure we give them sort of equal time, right? They're defense lawyers. They're pretty good people out there. Which is what we do at my law firm, the R&R Law Group. We help good people charged with crimes in the state of Arizona. If you know anybody who needs help, we'd love the opportunity to help. Free case evaluations and all that stuff. Links are down in the description below. rrlawaz.com. And I think we're rehydrated and we're not turning into parchment anymore, which means we can continue on with the defense closing argument. So the jurors are out there. They're all rehydrated. They're like, okay, that was pretty good. They're like, what'd you think? 7.5, 3.2, 8.1. What do you... really, they shouldn't be talking about any of it. I'm just joking about that. The court says, all right, everybody, get your butts back in here. We've got another argument to get to. Be seated. All right, be seated. Says Mr. Berkowitz. Okay. Berkowitz gets up. And remember, Berkowitz is kind of the good cop in this defense team. And he starts off very poetically. In 1983, the famous magician David Copperfield made the Statue of Liberty disappear. He was in the bay of New York Harbor in live studio audience, facing the Statue of Liberty. He had 100 people on the stage and he started talking. The Statue of Liberty was there. He was looking at it. It was surrounded by lights and helicopters, and on the platform he was on, there was scaffolding. And then the curtains dropped. And he talked at them for about 10 or 15 minutes. And he talked about the Statue of Liberty and what it meant. And he talked, and there was loud music, and there were lights, and there was smoke. And then he dropped the curtains, and the Statue of Liberty was gone. The lights were there. The helicopters were there. But Lady Liberty had disappeared. How did he do it? Something called misdirection. While he was talking at them, while he was talking about the Statue of Liberty, while the loud music was going on, while the lights were going slowly, ever so slowly, the platform in New York Harbor turned. And by the time he was done, the curtains dropped and they were facing New Jersey. Now, why do I tell you that story? Because this is a case about misdirection. What you just heard from the special counsel, their magic trick, was they had a short meeting on September 19th, 15 to 30 minutes at most. What did they make it turn into? The giant political conspiracy theory. That's what you just heard. All right. This case is not about a giant political conspiracy theory. It's about a short meeting. But because they don't have evidence to prove this to you, they want to misdirect you and focus on this. Let me talk to you about the evidence because these are serious charges. Mr. Sussman's liberty is at stake, and the time for political conspiracy theories is over. The time to talk about the evidence is now. The witnesses. So the people who are part of this large political conspiracy theory are the people at HFA, Rodney Jaffe, and Fusion GPS. They're the people that are supposedly involved in this conspiracy. You heard from all those people on the witness stand, all right? The government witnesses we'll talk about later, but Mr. Algor in his opening remarks quoted the testimony minimally. Laura Sego was in one meeting with Michael Sussmann where they talked about Alpha Bank. They did. I'm not going to come up here and say that Mr. Sussmann was not working on a story related to Alpha Bank or working with the New York Times on that. Of course he was. Opposition research is not illegal. If it were, the jails in D.C. would be teeming over, all right? Nobody got up there and said anything wrong with it. Let's talk about what the people actually said from the witness stand, not what Algor said. But as Mr. Algor said, the judge is going to give you instructions. He's given them to you, and he will say that what I'm saying is not evidence. What Mr. Algor is saying is not evidence. And what Mr. DeFilippis says when he gets up here after me is not evidence. First of all, we saw two witnesses associated with Rodney Jaffe. Steve DeJong, you may or may not remember him. He was an early witness. He pulled data and had no idea where it was going. Jared Novick, you remember him. He doesn't even know what DNS stands for. He supervised 3 people collecting data. He formatted a spreadsheet and he sent it over to Mr. Jaffe. Laura Sego, when you hear Mr. DeFilippis talk about Fusion, think about Laura Sego, because that is the only witness you heard from Fusion. The only witness. And it is their burden to bring people in, and they brought in Laura Sego. She said her role was to do open source research. She had one meeting with Sussmann and she had one meeting with the reporter, and the information she provided was accurate. Hillary for America. All of these people again. I want to focus you on the short meeting that took place. None of them. They all came up here. They're the supposed client. They didn't authorize him. They didn't direct him. But Mr. Mook said it would be malpractice, the head of a campaign, not to do opposition research. So what are the facts? Mr. Sussmann is a serious national security lawyer. Everybody that knew him, that got on the stand, said it. And he received what he believed would be a credible data from the world-leading DNS expert. And they provided that data to a Pulitzer Prize-winning journalist at the New York Times. The New York Times vetted and decided to run the story. Mr. Sussmann went to the FBI to give them a heads up. He did not ask for anything on behalf of anybody. The FBI called him back and said, hey, let us know the name of the reporter because we want to hold the story. And the New York Times held the story so that the FBI could do that. We'll discuss what they did on investigation, so to speak. There was no leak of the FBI investigation. The only story that ultimately came out that mentioned the FBI investigation was the New York Times story that said the allegations, according to the investigation, were unsubstantiated. And we'll get to all of that. Those are the facts. That's what you heard from the witness stand. And what are the key questions? Mr. Bosworth told you what they were, and we're going to run through them with all of the evidence this time. The first one, what did Mr. Sussmann actually say to Jim Baker on the 19th? Mr. Algor said there's not going to be any dispute about this. Wrong. There's a big dispute. There is no doubt that Mr. Sussmann sent this text. I'm coming on my own, not on behalf of any client. Want to help the Bureau. He says it's a true statement, by the way. We'll get to that. He sent that. We own that. But you know what? That's not what's charged in this case. And he's right. They're only charging him on the 19th date. What's charged in this case is what was said on September 19th in the meeting with Baker, where there are no notes, where there are nobody other than Mr. Baker's word, and we'll talk about that, all right? It's highly unlikely that Mr. Sussmann would have repeated that statement on the 19th. He had told him on the 18th that he wasn't coming on behalf of a client. There was a short meeting where information was exchanged. You'll see some other things that were talked about, but there is the only evidence you have of a specific memory of specific words used on September 19th are from Mr. Baker. So he got on the stand. Any notes? No. Pretty confident? 100% that I didn't take notes. Another thing he's 100% confident of. No agent. Did you bring anybody in the room with you for this 15, 20, or 30-minute meeting? Didn't do that. No other witnesses. FBI policy, and it makes sense, is when you talk to somebody about something that might be important, you do a report. Special Agent Hellman. The FBI pretty much takes notes in any interview. The purpose of a 302, that's the FBI report of an interview, is to pretty much document any observation an FBI agent might make. If it's an interview, you interview somebody, you're going to take notes. You're going to document anything that was talked about during the interview. It makes a lot of sense. And if Mr. Baker took notes, maybe we wouldn't be here today, right? He said he didn't want to be a witness. The last thing he wanted to do was get any information from Sussmann. He wanted to move him out as quickly as possible, take the information and pass it along. Let's talk about Mr. Baker's memory, because that's the only thing you have as to what was said on the 19th. We tallied up his I don't remembers. You can write it down. It's 116. And you remember him on the stand. He remembered certain things when Mr. DeFilippis was questioning him, and he didn't remember a lot when I was questioning him. His recollection was, of course, refreshed. Now, keep in mind that the notes that they used to refresh his recollection did not say, quote, doing this for any client and no specific client but a group of cyber experts. That's what he did. That's what their notes reflect Mr. Baker told them on the 19th. Isn't it possible, says this defense lawyer, perhaps likely, that what happened is that he knew from the text he'd received literally less than 24 hours before that he wasn't coming on behalf of a specific client, and that's what he's relaying. The rest of the information he learned in that meeting. Think about it. Why would Mr. Sussmann repeat it when he's coming with information? Do you have a reasonable doubt about whether Mr. Baker's recollection that it was repeated in the meeting actually happened? Well, let's talk about how it is that Mr. Baker's memory about this meeting came about. Either 15 minutes, 20 minutes, or 30 minutes, okay, on September 19th. In October of 2018, Baker says, I don't remember him specifically saying he wasn't acting on behalf of a client. Fair enough. It's about a year later or 2 years later. You would expect him to not have a great memory. But then in 2019, it says, quote, wait a second. He related some strange interactions with some number of people that were his clients. So then in 2019, suddenly he remembers that he mentioned clients, okay? And on the stand, DeFilippis said, well, that was a slip up, and Mr. Baker at least owned it. He said, no, that was wrong. It wasn't a lie because I didn't intend it to be wrong, but that was wrong. We fast forward June 2020, almost 3 years after the meeting, DeFilippis and Durham talk about Baker, and they talk with him. And he says Mr. Sussmann did not specify that he was representing a client regarding the matter, nor did he get asked it in that meeting. That's what he said in June 11th. And then they showed him the notes. Fair enough. And remember when I said, did the notes immediately refresh your recollection? He said it took a little bit of time. I think it took a little bit of time for me to process what I was reading and to reflect on what I remembered. Okay, is what he's saying to the jurors. So he's looking at his notes to try to understand what happened, and he sees that's what's said. And then he says, well, it must have been said, because he places it in the meeting as opposed to the text, because he didn't have the text. Remember, he didn't recover that until March of this year. And so isn't it probable, at least likely, that the information about, quote, no specific client came on September 18th, which is not charged, and not September 19th? What does he say about it? What does he say from that witness stand? I'm 100% confident that he said that in that meeting. Are you 100% confident of what you said to somebody yesterday? Are you 100% confident of what you may have learned 3 months ago? And something that's even important to you, an important interaction, are you sure that it really happened on that day as opposed to another day? All right. That is reasonable doubt. And the case is over if you don't believe beyond a reasonable doubt that Mr. Baker's memory, 100% confident that he said in that meeting. And the case is over if you don't believe beyond a reasonable doubt that Mr. Baker's memory 100% confident that he said it in that meeting. Let's think about what else Mr. Baker, with the benefit of his notes being refreshed, has changed on, right? How long was the meeting? 30 minutes on the stand, but he told these guys earlier 15 to 20 minutes. He says, I don't remember that difference. What about how he spoke with Mr. Bill Priestep? He said, I'm pretty sure it was a phone call, but that was my terrible handwriting. You remember that? He also said that he remembers DeFilippis and Durham saying they didn't talk on a phone call. Said, I don't remember that. Is he going to go through all 16s? All 116? I don't recall. I sure hope not. Back in March of this year, defense attorney asked him if he remembered telling the agents about the New York Times story. I don't recall. And he says, by the way, I don't blame him. It's hard to remember what happened 2 months ago, let alone 5 years ago. He says, ladies and gentlemen, when you go to the jury instructions, instruction number 16, you get to assess the credibility of witnesses. Whatever I say about Mr. Baker's memory, whatever you decide about his memory, you guys get to pick. But there are certain guideposts that this judge gives you: the demeanor, the behavior on the witness stand, whether they seemed truthful, the accuracy of their memory and recollection. I submit to you, the government is not proven beyond a reasonable doubt that on September 19th, Sussmann repeated the words from his texts. And this is very interesting. So this is like a very technical argument that I did not actually see. I see what he's explaining, but I'm not sure it's going to really land with the jury. And I'll jump back in on this in a minute, but it's a long one, so I just want to pause on before I forget this thought. He's really dialing in on the distinction between the 18th and the 19th. And he's saying that there's no if Michael Sussmann on the 18th before the meeting said something on the text message, you don't need to say that, just practically speaking, in the follow-up meeting. Okay, so it's almost like if I said, hey, I've got to come over. I want to have a meeting with you. I've got to tell you this big thing about X. And then you get to the meeting and you say, hey, thank you for having this meeting. I want to tell you about this big thing called X. And if it's like too repetitive, it's like you don't need that statement because you already said it the day before. The person at the meeting would just be looking at you and be like, yeah, I know you told me that yesterday, that you wanted to talk to me about this. And now you're telling me that again. So you're telling me twice. The defense is saying he wouldn't have needed to do that. So he said, I'm not coming on behalf of a client. And they're saying that could be a lie. They don't even care. Maybe that is a lie. They're sort of neglecting that because that's not what's being charged. We're only talking about the 19th date. So if that 18th date is irrelevant, forget it. They're saying he already lied on the 18th. So he wouldn't have lied on the 19th because he was already lied. You don't need to lie twice. It's like you've already explained yourself. Don't tell me again. And it's very technical, but it's basically what he's explaining there. And you know what? He writes, if you go back to the jury room and they didn't prove that beyond a reasonable doubt, you don't even need to get to the other questions because you got that one element. It's gone. You can go home. Is what he said false? He says that is the second issue. So remember the issue. Let's assume that the statement was made. I did not go on behalf of a particular client. Okay, that is a true statement. There were two clients that he talked about. The two clients are Hillary and Rodney. Let's take them in turn. Number one, when you go somewhere on behalf of a client, you're advocating for the client. You're asking for something. You want feedback. You're advocating. You're asking. Mr. Sussmann didn't ask Baker for anything. Undisputed. His testimony before Congress was as follows. Sussmann, Baker during Congress said, didn't want any follow-up. Baker, when questioned by DeFilippis, did Sussmann make any particular request? No, he didn't ask me to do anything. We have the February CIA memo, which talks about that as well. He says these are all consistent, okay? Sussmann, if you're representing somebody, you want something back. You sort of, I'm an advocate for you. I need this. I'm giving you this in exchange for that. Kind of an implied contract. Says it's very consistent here. That doesn't mean he didn't have clients, though. Hillary for America was a client. Rodney Jaffe were clients. But there's a difference between having a client and going somewhere on their behalf. So he went to the FBI, having a client, but not going to the FBI for a client. A little bit of a nuance there. Let's now talk about the evidence that the special counsel points to relative to whether HFA, Hillary for America, was his client at that meeting. What's the first thing you have to do? How about Ask the client, was he there on your behalf? Mr. Elias, and he goes through testimony here. Mr. Elias, did he seek your permission? No. Did you authorize him to go? No. Did you tell him to go? No. General counsel for Hillary for America on the stand said that. The lawyer for Hillary for America is his point. Mr. Mook was called. Did you direct Sussmann to go to the FBI? Absolutely not. Did you authorize him? No. Did anyone? No. The only other HFA witness, Miss Fine, same thing. Nobody from the client asked him to go or authorized him to go. And it's even more significant than that. It wasn't in their interests for him to go. In September of 2016, would the campaign have wanted to engage with the FBI? Mook says, speaking for myself, no. Remember, he said they were investigating Hillary with the email issues. There were a whole host of things. They didn't trust him. They even refused to go to a briefing with the FBI. They disliked him so much. You heard that from Mr. Mook, who I would submit to you had nothing to gain other than being honest. Elias, would it be a good thing or a bad thing for the campaign to go to the FBI? I don't believe. I would have thought that was a good thing. If the New York Times was going to run this story, like that's their goal, right? Any number of things can prevent that from happening, and he was right. Mr. Sussmann did work with Mr. Jaffe. They provided the information to the New York Times. That's absolutely true, right? That's different than whether they went to, and that story would have benefited the campaign. And therefore, time was billed to the campaign for that work, all right? That's different than the charge in this case. They point to his billing records, okay? Let's take a look at those. Mr. Algor put something up for 4.5 hours and 3.3 hours. They seem to think this is compelling evidence. All right, he said, use your common sense. It's obviously the Alpha Bank project, but where is the evidence? There is certainly some Alpha Bank work that's done, but Mr. Sussmann, you heard from different witnesses, was doing other things. What's missing here is a meeting. Number one, look at these records. A meeting is missing and FBI is missing. Don't you think if he went to the FBI on their behalf, he would say FBI meeting with Jim Baker, right? Nothing, no proof, smoke, mirrors, noise. And do you know what? Mr. Sussmann, when he wanted to, he knew how to build a campaign for meetings. This is Government 559, okay? You'll have it back there. These are just a few examples. There are voluminous exhibits, all right? This is HFA DNC, okay? That's what these bills are. Meeting. No meeting on September 19th. But do you know what? He doesn't just know how to bill meetings. He knows how to bill with FBI engagement. He knows how to write those letters this time. August 5th, FBI. August 6th, FBI. 8th, 24th, 27th. All billing records. All of those are engagements. And it is not a surprise because Sussmann was representing these entities in connection with the tremendous hack that you all heard about, right? You heard Mark Elias from the stand saying, the Russians hacked our servers. They were releasing it. Remember when he said they were releasing it on the eve of the convention, systematically doing it. And then he says Donald Trump gets up and talks about, go find her other emails. He is representing them before the FBI on these issues, and he bills for it. And not just that, he knows how to bill for meetings, for FBI and for FBI meetings. This is a meeting from April of 2015, okay? Over a year beforehand. And it's with Mr. Jaffe, meeting with FBI, June 16, meeting at FBI, August 16, meeting at FBI, October 16, meeting with FBI. Don't you think that's the sort of evidence that you'd want if someone was on trial for their liberty, that they have to prove something beyond a reasonable doubt? The billing records are their best evidence? No FBI meeting? The flash drive, smoke, mirrors, noise. They come here with a Staples receipt and a Google map and they say, you guys are all set, okay? Why don't they tell you? Those were purchased on September 13th of 2016. What don't they tell you? He was doing a tremendous amount of work for the campaign. Flash drives purchased on September 13th, the 13th. When did he have the meeting? The 19th. When did he send the text message for the meeting? The 18th. What else happened on the 18th? Do you remember? That's the Trump freakout email. Remember, there was a story that's about to come out and Trump is freaking out. And that happens at 5:08. The Sidney Blumenthal thing. Quote, campaign is having a major freakout, according to some Republican source. What's causing it? Anticipation of the investigative story coming out from the New York Times. The subject is described as Russia and a disaster. It's after receiving that email that Sussmann reaches out to the FBI 5 days after the flash drives. But you know what? You don't need to even understand that to know he didn't bill expenses to HFA for this meeting, all right? So this is the date. 7/24 is when he sends the text message set up the meeting. This is a flash drive purchase 5 days before. Now, who does the billing Who does he bill the transportation to? Does he bill HFA for that? The cab back and forth? No. FBI meeting, 919, his records. Attend the meeting at the FBI. Firm charge. You heard that from the stand. It was a charge to the firm. You heard that from Miss Arsenal, not to HFA. Same thing on the taxi, office and back. This is another exhibit. I'm going to write it down, 403. All right. And do you know what? Mr. Sussmann knew how to bill his clients for transportation. Just take a look. DNC data breach, cab from office to client, attend client meeting, okay? When he went on behalf of a client, he billed the client for those expenses. Now let's talk about Rodney Joffe. Again, this is to show he was not at the meeting on behalf of the clients. Again, looking at his congressional testimony, we already saw Sussmann said in October he wasn't looking for the FBI to do anything. He had no ask. Baker said the same thing. You saw the slides before. No ask on behalf of anyone else. CIA memo, you saw that. Ask all of them. All consistent. Okay, so Mr. Joffe was Sussmann's client, a client of Perkins Coie. This is the February engagement letter of 2015. Here's what it says. Unless otherwise agreed, the terms of this letter apply to additional matters we undertake. So he's a client. He provided information to Sussmann. All of that is true. But you know what? There are no billing records for Joffe attending a meeting on September 19th or anything else in August, September, October of 2016. Let me repeat, says defense lawyer. There are no records of any bills to Mr. Joffe for a meeting on September 19th, 2016. There are no records of any expenses charged to Joffe. And their theory seems to be that he was there because Joffe was going to get some sort of business benefit. Remember the questioning and what Algor said? It doesn't make any sense. He received tens of millions of dollars in contracts that he was going to get from the government. It was for DNS data that he separately provided. What business benefit would Joffe get from Sussmann going to the FBI? What economic interest would he get? Zero evidence of that. What's the evidence of Joffe's motivations? Well, we called, as the defense, Special Agent Grasso to the stand. Remember that? He had spoken with the government numerous times, but when we called him, we said, what was his interest? Retired Special Agent, 30 years, FBI. He was in it for the good and a good Samaritan. You heard testimony that he was terrified for his security about being associated with this information. He was concerned about what the Russians could do. And you heard the special agent say this is a real threat, right? Those Russians, if you can squeeze. I'm waiting for Putin. We haven't gotten Putin yet. Don't know if we're going to get it, but we got Russians. Business interests? No. Now, their best evidence, and they will show you, is Mr. Sussmann's congressional testimony, all right? And I want to hit this head on directly. We're going to talk more about this in Congress over a year after the meeting. And they put this up, remember? They went up and read it. It's midway through a lengthy congressional testimony where we talked about the DNC hack and otherwise. And Sussmann said, it's not correct. And this is the response to the question about whether he was directed by his client to go. He said, but when you say my client directed me, we had a conversation as lawyers do with their clients about clients' needs and objectives and the best course of action to take for a client. And so it may have been a decision we came to together. I mean, I don't want to imply I was directed to do something against my better judgment or that we were in any sort of conflict, but this was, I think, the most accurate to say it was done on behalf of my client. Okay. God, talk about lawyer talk. Good Lord. Now, Mr. Joffe was a client. Mr. Joffe had provided him this information. They had gone to the New York Times. Sussmann had passed along information to the FBI. All right. He even spoke to Joffe about that. Was he there advocating on behalf of, or are those words inaccurate, imprecise, the result of, being over a year and a half and some afterwards? You heard plenty of witnesses from the stand. Do you think that he intentionally lied about this? Or do you think it's the product of confusion? Uh-oh. It's not good. He's just confused. It's not looking good. Let's see what else he had to said that day. At the end of Wednesday, I got up and under what's called the rule of completeness, read another portion of his testimony. And I think this is really what's important. He said, quote, but to be clear, I told Mr. Baker I didn't want any follow-on. I mean, I was sharing information. I remember him telling him at the outset, I was meeting with him specifically. Any information involving a candidate, he reads this whole stinking paragraph. Yeah, and so I had no request. He says, context matters. Does it look like he's there on behalf of Joffe, or does it look like he was there to help the Bureau? I was coming to him mostly because I wanted to be able to decide whether or not to act, or to share or not to share information to insulate or protect the Bureau. I don't know. I just thought he would know best. So yeah, poor Sussmann. Okay, anyways, I'm trying to limit my commentary today a little bit. I'll save that for later. Okay. Jim Baker's trial testimony. We have another quote. If there were a matter of actual national security, and if there were a newspaper article about to come out on the matter, the FBI would want a heads up, is the question to Jim? Yes. Because if the FBI wanted to investigate, you don't want the bad guys to know what you're looking at, right? Yes. Because if they published the article about this, other people could take it down, and that would make it harder for the FBI to do their job. Now, the defense attorney is still going, says, Mr. Algor raised the point, well, why didn't he go to the FBI initially if he was so concerned? He says, you heard, he went to a Pulitzer Prize winning journalist at the New York Times. Nobody has suggested it showed direct communication. He gave the New York Times the information. They talked about various things. You heard about the Fusion white paper, which we'll get to. There's a Wikipedia document. It's all open. He says that's a Wikipedia document, essentially. All open source. You can find it online by Googling it. And finally, we move over to question 3. Did he intend to say something false? Who is Michael Sussmann, says the defense attorney, changing gears a little bit. You heard from Jim Baker that Sussmann is ethical, credible, honest, a serious lawyer, a smart guy with DOJ experience. Tricia Anderson, who took notes, you remember her, well-respected national security and cyber lawyer. You heard from some character witnesses, Gemma Elliott Stevens, Martha Gam, had confidence in his truthfulness, saying, I would bank on it. You heard nothing other than Sussmann was a respected national security lawyer who was serious and was ethical, credible, and honest. And what did he have to gain by giving this information to the FBI on the eve of the New York Times publishing the story? He had a vibrant national security practice, top secret clearance, all right? I mean, he had a badge that allowed him to get into the FBI. Top secret clearance. He had a relationship with tech companies that he needed to interface with law enforcement. What possibly happened on the eve of September 18th that caused this man, who has a reputation for credibility and honesty, to decide to break the law and lie to the FBI? Donald Trump is one. It doesn't make any sense. Everything to lose, nothing to gain. The motive is this political conspiracy to do opposition research. Doesn't make any sense. So let's talk about Mr. Sussman's state of mind with respect to this information. You've heard a lot of information from the FBI, who did some sort of investigation, which we'll talk about. They never got back to Sussmann. They didn't say to him, right, this stuff is nuts. Nobody ever got back to him. They didn't even let him know. That's why he went to the CIA saying, I'm frustrated. Nobody said anything. I think this is concerning after the election, mind you. So he had reason to believe Rodney Joffe. Joffe was his client. Steve Jong said he's well respected. Grasso said he's reliable. The stipulation that I read into said that Joffe had received tens of millions of dollars because he had major government contracts. And why would Sussmann doubt Joffe? There's no evidence saying that Sussmann's a DNS expert. So he's trusting a Pulitzer Prize winning journalist. And then on September 22nd, after Sussmann had gone to the FBI, there was an article that came out saying there was an imminent story. Baker writes and says the reporter on the matter we discussed is Eric Lichtblau. Sussmann relays that communication, sends that back to Baker, and the FBI can call Lichtblau and check on it, saying that Sussmann's essentially helping him here. Sussmann, when he relayed the information, says, I believe it is as to the people. And I'm going to write this down. 2 exhibits here. October 19th, 2018, Sussmann forwards Baker a text. We're now 2 years after the conduct, right? September 19th, 16, we're now in 18. We're now in October 2018 at a time when Baker happens to be interviewing at Sussmann's law firm. Uh-oh. Remember that Michael Sussmann was trying to get Jim Baker a job at his law firm, Perkin Coie. They had an interview and Jim Baker didn't get the job. And then he went over to Twitter, and then Sussmann actually sent Baker like Twitter's org chart and all sorts of weird stuff. And this is kind of like saying Baker is kind of like a dummy who might have been wanting to sort of suck up a little bit to Michael Sussmann. And then now that he didn't get a job at that law firm, maybe he's a little bit angry at Michael Sussmann. Let's see where this goes. Baker happens to be interviewing at Sussmann's law firm. He said, I believe I met with John Devaney, the head of your firm. He said that from the stand. And so what does Mr. Sussmann send him? Our Michael is an honorable man. Talking about more testimony from Lichtblau. He's very reliable. And he's an amazing guy. So let's talk about what actually happened here, because this is really interesting, okay? How does this come about? Here we've got October 2018 in Sussmann's mind. You know, he's here on behalf of a client and Jaffe. Where does it start? March 2017. I have a handy little timeline here, which I'm sure you guys are thrilled about. But right, the meeting happens in September, and then in March 2017, there's this big briefing 5 or 6 months later, and we talk a lot about that meeting because there's numerous notes that they had there. There's an enormous briefing among the bigwigs. Trump is now elected. He's bringing in his own people. The Obama, FBI, DOJ, they're all on their way out. They have this meeting in March. We have several notes they brought in. Ms. Guajar's notes said attorney brought to the FBI on behalf of his client. They were acting and briefing the acting attorney general. We had another person who had very similar notes. Attorney brought FBI on behalf of a client. And in March, same meeting, did not say who the client was. We listened to those two ladies testify. So how does this happen, right? Priestep and Anderson were at this meeting. Baker was at this meeting. Nobody stood up and goes, you got it wrong. No, no, no. This is super important. He was not there on behalf of a client. Nobody says anything. You heard that. So what happened? It's a great question, right? Well, this meeting in March, the interactions with Baker and Sussmann were over a 4-day period. September 18th with this text all the way to the 22nd. That's it. Those 4 days, 15 to 30-minute meeting, a couple of phone calls in between. And what's really significant about the phone call afterwards is they happen after Priestep and Anderson's notes, okay? So you're with me so far. Not really, actually. He's sort of meandering. One thing to think about is to look at the CIA notes, because that's going to tell you what's going on in Sussmann's mind at the time. What does he say to the CIA? Well, he meets with Chattison. You heard him from the stand. He had somewhat of an accent, but he spoke to Sussmann, who reached out after the election to provide this information. It certainly wasn't helping Hillary for America at that point. And he says, I've got a client. Then in the paragraph below, it says Sussmann worked with the intelligence community before. He's describing Rodney Jaffe here, talking about I'm not representing a particular client. And so here's the real question. What did Mr. Baker and Mr. Sussmann talk about on September 21st, right? That's a 13-minute phone call when Baker calls him back after the meeting on the 19th, 13 minutes. I asked him what was said. And he said, told him we wanted the name of the reporter. And he said he had to check with the person and get back to me, okay? I just said it in 10 seconds. What happened to those other 12 and a half minutes? I'd suggest to you, says the defense attorney, it's certainly reasonable that you can use your common sense that he would have said, I have to talk to my clients because I can't release the name of the reporter without checking with my client. Mr. Baker said he thought he was checking with cyber experts. Well, the source of the information, right? He would have said, I'm not. He certainly would have indicated it's not most likely. It's the only explanation for why in March. So let's take a look at the text. He's kind of jumping a little bit. So he has that 13-minute call. He hopes to write back that night. Jim, sorry, been unable to respond sooner. It's clear from the conversation they talked about who Mr. Sussmann had to check with. I think he's stretching here, to be honest. He's sort of really filling the gaps in on this. So he was speculating that Sussmann didn't say the thing in the actual 19th meeting because he said it on the 18th. And now he's also asking the jurors to speculate about sort of filling in the gaps on this other meeting, as though this is, he's sort of asking them to presume that Sussmann would have said, let me check with my client, and then he wouldn't have said it. He's asking the jurors to presume a lot of things here. Let's just put them down. He introduces this memo. He says he calls Mr. Baker after that. Call me when you can. What happens? He checked, he came back, and he gave him the name. And that brings us to March, when people briefing in Mr. Baker's presence say he was there on behalf of a client. He did not say who the client was. Very consistent with what happened at the CIA, he says. So I want to give you some context. I want to give you some evidence. And he's going to go through some more testimony, which we're going to fast forward through here. He's going back through a lot of the bill testimony. Let's see if we can get another sort of media material here. I think we're talking some materiality here. Look at what he did back then, not what they're saying now. Look at what they did, not what they're saying now. And if you're saying politics actually matter, they're talking about materiality. This is one of the elements of the offense. If it's a white lie, it's not a crime. It's got to be a material lie. If you're saying that politics actually matter, in other words, if Sussmann had said that he was there on behalf of Hillary, who's a political figure, if that actually matters, if somehow we get past this and say it would have mattered, Special Agent Hellman said, I mean, from a technical review, we did nothing. If there were political motivations, would you have done anything differently? And he says, from a technical review, nothing would have changed. So sort of attacking materiality there. He says, now, by the way, nobody cares anyways. Everybody at the FBI thought the data came from a political party. I mean, it's not even an odd type of thing. It was actually not. Because Sussmann has DNC and HFA tattooed on his forehead, right? He's dealing with them all the time. They assumed that's where the data came from. Jill Baker and Bill Priestap in the notes, what's the first thing that Baker says? He says, represents DNC and Clinton. He says, not on a particular client. Bill knows this already. He says, by the way, how significant is this? Other than these two, this supposed important lie doesn't get passed down to anybody, right? There's no record of a file or text on this. He goes through, talks about some of the testimony from Scott and others. In trial prep, they're going through some of Sussmann's interviews. Let's see if we can find out what is coming up next. I'm trying to dig in. Cyber experts. We're talking about Dagon now. Do you know who didn't have a 20-minute call with him? The FBI. So he's sort of at the section now where he's blaming the FBI. They didn't talk to somebody they believe to be the author of the white paper to get their motivations to say any of this. Going back through Ryan Gaynor's testimony saying your investigation was incomplete without this evidence. Yes, it was. Remember, a big part of this is to blame the FBI. And this has been an interesting battle ever since this started. John Durham, for many people at the Justice Department and the FBI, he's prosecuting this to sort of uphold the integrity of the FBI, saying, no, you lied to us, right? The DOJ and the FBI, they're supposed to be on the same side. FBI is like the law enforcement arm. It's like your local police department, and the Justice Department is like your local prosecutor. So if somebody goes and lies to the FBI, prosecutor's not going to be happy about that, like lying to your local police department. And what they have said is the FBI screwed this whole thing up. If they would have handled it appropriately, Sussmann would not be the scapegoat on this. And they're talking about a lot of this. You know, if somebody would have brought this and it came through a confidential human source, it would have gone this way. It didn't. Saying there were some witnesses who were even, and this is some of the prosecutorial misconduct stuff. Even witnesses who were in this trial at the FBI, people like Ryan Gaynor, were the subject of criminal investigation. And he's sort of taking us back a little bit. Hopefully we're getting to the close. He says, all right, now let's go back to the giant political conspiracy theory, because I expect you're going to hear a lot from DeFilippis about this. First of all, I'm going to ask you to use your common sense and look at the evidence. You know, don't come here with meeting minutes that don't reflect any substance. Don't come here with phone records that could show any number of things. All these records with Mr. Jaffe. Look, he's talking to him. Look, he's talking to him. He's talking to his client, right? He's also talking to his client News Star. You don't know what's happening in those calls. That's not proof beyond a reasonable doubt. And when you see the things that DeFilippis puts up, ask yourself, where is Mr. Sussmann? He's going to be on some of them, but he's not on most of them. And ask yourself, who from the witness stand actually said what he's saying? Now, I expect that you remember the instruction about circumstantial evidence, right? Well, you can assume there was a billing record, there was a meeting, and so it must be this, circumstantial evidence. And I think the example that he gave, and I've been doing this for 30 years, it's the same example. You go to bed at night, there's no snow on the ground. You wake up, there's snow. It must have snowed. Well, that's what happened here. What's happened here is that special counsel's office bought a snowmaking machine and they blew that all over the lawn and they want you to think it snowed. That's not what happened, okay? They didn't call witnesses to prove any of this information that they put there. And I'm going to try to talk about the evidence. Speculation, reporters. Mr. Sussmann talks to reporters. Yes. Look at his records. Ellen Nakashima, Washington Post. Further communications with the Washington Post reporter. He had relationships with reporters. Absolutely. Look at that. It's billed. He talked about it. You've heard about Mark Hosenball from Thomson Reuters. Well, he built that to Thomson Reuters. August 1st, communications with Thomson's. No evidence about any of this being billed to Alpha Bank. Fusion again. Look, think Laura Segal. Fusion was researching Donald Trump before the campaign came along. Laura Segal, the only person you didn't hear from Peter Fritsch, you didn't hear from Glenn Simpson, you heard from Laura Segal. Open research meeting. I look at what's on the public record. One meeting with Sussmann and Mr. Jaffe where they talked Alpha Bank. Absolutely, one meeting. They talked about work. Mr. Jaffe had provided information to Sussmann and they discussed it. Opposition research. Nothing illegal about that. She had no knowledge of Mr. Sussmann's meeting with Baker. That came from the witness stand. Never discussed leaking, never discussed the fact that they were investigating the allegation. One meeting with Fritsch and Foer. They put up the Fritsch email. Laura Segal's the only one you heard from Fusion. And you know what? There was no leak. Think about that. There was no leak. The story came out, the Franklin story. You saw Mr. Mook, who was up there for an uncomfortable 5 minutes looking for the story. Hey, does this say anything about an FBI leak in there, Mr. Mook? He read it carefully. No. You've got the article. You can look at it yourself. They're not mentioned in Franklin Foer's story. Don't you think if the intention of the campaign and Mr. Sussmann was to leak the FBI story, it would have been in this? And what did they report at the end of October? Quote, FBI officials spent weeks examining computer data. That's the story. That's the leak. That's the conspiracy. Please. And you could even say this is misleading, right? He acted like there was a real investigation. Let's talk about that investigation. It was shoddy. It was an embarrassment. They get the name wrong of who referred the information, right? And that was a typo. Whoops. From the original opening. Help, right? And they did. Remember that? That was the, whether this came from the DOJ or from the Office of General Counsel. That's right. Hellman, within, a day and a half of getting the information, said it looked like it was written by someone with a mental disability. They never interviewed Sussmann. They never asked to interview the people who were the source of the information, despite the fact that they knew who they were. Grasso had an anonymous reporter. And you know what they did? Let's go talk to Alpha Bank. They said they paid somebody to look at this. What kind of investigation? He says, this is the FBI. He says they go talk to a Russian bank who they hired. And it's true. They did. They went and talked to Mandiant. Remember that? So the defense is like rubbing the FBI's nose in this. The FBI had reached a, quote, logical conclusion to the investigation within 2 weeks. And the only thing left was to interview Sussmann for whatever. And they weren't allowed to do that. They weren't even told who it was. That was their investigation. And now he talks about the confidential human source stuff. They didn't talk to people who challenged their investigation. Tunnel vision says, thank God you're here to objectively evaluate the evidence. And he talks about all the witnesses. I'm going to say, you evaluate his credibility, talking about Baker. You look at what he did. You assess whether he's accurate. Met with them 10 times. He had been under investigation. He was concerned about being investigated, saying that Baker is basically compromised. Curtis Heide, Ryan Gaynor, a number of times, over and over and over again, they met with them. Why so many times? What did they need to get out of them? Why not just ask them to tell what happened? Jim Baker, when you made the statement, was it accurate? Yes. Okay. And that was something, just a slip up. That was DeFilippis' question. Here he's talking about, I get to be investigated for another year or two by John Durham. Lovely, right? He's sort of thinking, oh, Baker's compromised. All right. It's no wonder he delivered on the stand. Oh, man. Calling Jim Baker a liar because he's under pressure for Durham. Curtis Heide, he was accused and under investigation for holding back information that suggests somebody could be innocent in connection with the warrant to get a wiretap or a search warrant. You don't think he was concerned? Agent Hellman, DNC, was that a typo? I don't know. When you said the only one suggesting it, isn't it true that it was Mr. DeFilippis who suggested that it might be a typo? Yes, that's correct. Agent Gaynor, we talked to him at length. It was intimated, he was told when he gave them information they didn't like, that he was the subject of criminal investigations. And then he changed his story. Number 16, you can consider the credibility of witnesses and the accuracy of their testimony. You heard 2 character witnesses, you'll remember them. You heard the instructions. You may consider this evidence among other evidence. Think about those character witnesses when they're done. and think about who they brought to the stand to testify against him from the government. Now, I've probably got 5 or 7 minutes left, I think. The court says 10. You got 10. Okay. Defense says, DeFilippis is getting up here soon, and he's a talented lawyer. You've seen him in the courtroom. The government has the burden of proof in this case. And so he gets the opportunity to speak last, right? I don't get a chance to come back up here and respond to what he says, so I need each of you to do what I would do, right? They put a witness on. Me or Mr. Bosworth come and question them over and over and over again. And then we do that, when we do that, other information comes out. You can bet whatever he says, one of us has an answer to, but we're not going to get a chance to do it. So each of you, when he says something, think to yourselves in that jury room, what would Mr. Berkowitz say? What would Mr. Bosworth say? Right? I need you to do that. Interesting little closing argument tactic there. I've not heard that one. And I've got some questions for Mr. DeFilippis. So he's going to give them the questions to ask. How can Mr. Baker be so confident that Michael Sussmann made the statement on September 19th when he took no notes, as opposed to September 18th, the date of the text? 100% confident. How could Mr. Sussmann go to the FBI on behalf of the Clinton campaign when no one from the campaign authorized or directed him to do so, when it was not in their interest? How come the March 6th, 2017 notes say the Alpha Bank allegations were brought to the FBI by an attorney on behalf of a client? And why did special counsel only show Mr. Baker the notes, but not the March 6th notes? He was at that meeting. Why didn't they show him something that's not on behalf of a client? And what did Mr. Baker and Mr. Sussmann talk about in July? And why did Mr. Baker text Jim a copy of the article? And why did Mr. Sussmann go to the CIA after the election if this was all part of some scheme? The most logical answer here would be that he actually was concerned. You heard the testimony. He said he was frustrated. Nobody got back to him. He was concerned. You heard the testimony. He said he was frustrated. But Sussmann didn't test. Okay. Mr. Jaffe was concerned. Why didn't they interview him or the underlying source of their data if their motivations mattered? If they'd done that, maybe we wouldn't be here. Why did they meet with the witnesses so many times? We'll get to the instruction in a second. I'm not from DC. I'm not a politician. I'm a lawyer. I represent Sussmann. Your job is to listen to the evidence. I asked each one of you if you would do that. What comes from the witness stand, not from their mouths or my mouth, and you said you could do that. It's your turn to do justice to prevent an injustice. I ask you to listen to the evidence and think about the evidence, and it's a special part of being in a court like this. I love practicing law because you get to be a part of justice and to prevent injustices, and it's now going to be on you. Let me read the instruction to you. The government has the burden of proving this all beyond a reasonable doubt. It's the reasonable doubt standard again. Reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate. However, it's not an imaginary doubt. They haven't met that burden. They haven't even come close. This case should never have been brought in. I ask you to return not guilty, not guilty, not guilty. Thank you. Thank you, Mr. Berkowitz. We're going to take another 10-minute break, says the judge, and then we'll have the government's rebuttal. So honestly, that was not all that great, in my opinion. I think that, he did what he could on this case, but when you start to when you sort of ask the jury to fill in the gaps, I think to too much of a degree, you start to lose them. In this case, there were two big gaps that he wants them to fill. One, he wants them to say that because Sussmann lied on the 18th, that he wouldn't have lied on the 19th. And I don't think that the jury is going to fill in that gap when they've got the conflicting evidence from Jim Baker. Baker saying, I'm 100% certain that at that meeting, he said it. I think it's going to be tough to overcome that. And then they're also asking him to asking the jurors to fill in the gaps on the conversations that took place after the meeting, right? Before and after the meeting. They talked many times after the meeting, and Sussmann was having conversations about whatever. Jurors fill in the gaps. Now, the standard argument saying that the government has not met their burden of proof, right? That's standard defense argument. Basically, every single case, you have to have that argument in there. But you have more success, and these guys have tried many more trials than I have, certainly, right? He's been doing it for 30 years. But what you see out of a jury, I think, is if you can give them an alternative theory that they can latch onto, that's a lot more useful. And he started to do that, I think, a lot here, but we're still missing, like, if they weren't talking about FBI, Sussmann, Russia, Alpha Bank, the Jim Baker meeting, what were they talking about? What was all of that about? I mean, I know it's this sort of national security conversation, but I think you're asking the jurors to sort of insert something that is too far removed from the underlying conversation. It's asking them to look the other way too far. And I'm not sure that they're going to be able to do that. And his closing was sort of, I think, throw the kitchen sink at it, which is not a surprise, right? That's sort of also a standard defense. Now, I summarized some of this previously, and I'm pretty happy with the summary. I think we got most of it. They talked materiality. They talked prosecutorial misconduct without saying that, right? They didn't say that. There were some billing errors they referenced, having clients versus working for clients. Baker's memory is bad. I think on this one, I would say like Baker's like integrity is bad. I mean, they really sort of like hit that pretty hard. And I forgot to share the mind map. I just dropped that in the chat. So Baker's integrity bad, right? Saying that, man, this guy's sort of even dishonest. He was very pressured by Durham and special counsel in order to changing his testimony, and kind of a hard thing to do. I'm sure that's like Sussman's friend, so they're kind of throwing his friend under the bus, which kind of stinks for Baker, but that's what happens in criminal trials. Now, we're not done. All right, we have the second close, the reclose, the prosecutor's second attempt, because they get 2 times. They get all the police, they get all the money, they get unlimited budgets, they get prosecutors out the wazoo, they get all sorts of special access and privileges and laws and badges and parking and everything. And they get 2 closes. Meanwhile, criminal defendants are like, good luck. Yeah, you're on your own. The whole system's rigged against you, but sorry, you also only get 1 closing argument. The prosecutor gets 2. What a joke. Cheers, my friends, to 1 closing argument. And since we're eliminating our parchment, we're going to gear up for round 3 of closing arguments as we wrap up with DeFilippis. Now, the jurors are out. They're using the restroom. They're dealing with their parchment issues as well. They're rehydrated. It's warming up in Arizona. Every time it's summer in Arizona, it's really hard to stay hydrated. Like, you go through like this 2-week phase where your body's adjusting, and you step outside and the air literally sucks the water out of your body, and you turn into like a little prune, a little grape for a while until your body recalibrates. And we're in that season right now. So it is, it's a challenge to stay hydrated. But I just took a break, so hopefully that helps. Okay, and without any further ado, we are almost done on the day, my friends. We've got DeFilippis is now up, delivering the second close. Judge says, all right, everybody, it's Memorial Day weekend. I told my wife I got to get out of here, so get your butts back in the juror seats. Please be seated, everybody. DeFilippis says, thank you, Your Honor. Ladies and gentlemen, there are sometimes close cases. This is not a close case. This is not even close to a close case. Now, ladies and gentlemen, I want to start by reminding you of one of the instructions that Cooper gave to you, which is that lawyers' arguments are not evidence. The evidence are the documents, the testimony, and the materials you saw and heard over the last couple of weeks. Ladies and gentlemen, it's appropriate that the defense started by talking about a magic trick, because what you just saw was a magic trick. The defense is trying to make all of the evidence you saw the last couple of weeks go away. They've come up with a retroactive explanation for the evidence that doesn't fit together. Ladies and gentlemen, when you look at the actual evidence, your common sense will tell you what happened here. Your common sense tells you what happened here, which is that the defendant made a false statement. He knew it was false and it was material. The defense is trying to explain away that lie. They're trying to lawyer away the defendant's lie. Don't let them do that. And let me say, ladies and gentlemen, we absolutely agree that it is the government's burden here. It is the government's burden, and we embrace that burden, but the government has met its burden. Now, Mr. Berkowitz walked through a number of arguments very quickly, and it was a lot to take in. So let's just break it down. Let's get to work and consider the arguments he made, and I know you will in the jury room. Ladies and gentlemen, Mr. Berkowitz began by saying that you don't have proof beyond a reasonable doubt that a false statement was made, that you don't have proof beyond a reasonable doubt that Sussmann lied to Baker in the September 19th meeting. That's false. You do have proof beyond a reasonable doubt. And what is it? First, and most importantly, you have the testimony of Mr. Baker. Mr. Baker came on the stand to testify at the trial of his friend. He came on the stand and he told you he was 100% confident of what Mr. Sussmann said in that meeting, and you could hear. You saw him on the stand right before he said 100%. He choked up. He hesitated. Why did he do that? Because he didn't want to be here. He didn't want to testify against his friend, but he did it because he had to, and because it's the truth. Mr. Baker, this was probably the last place in the world that Mr. Baker wanted to be last week. And he said under oath that he was 100% confident that his friend, Michael Sussmann, said in the meeting that he was not doing this for any particular client. Ladies and gentlemen, would James Baker come on the stand under oath, a former high-ranking FBI official, and subject himself to the penalty of perjury to do that against a friend if it weren't true? No, he wouldn't do that. None of us would do that, would take that risk for a friend. The reason he did it is because it is true. Ladies and gentlemen, that alone is proof. If you credit Mr. Baker and his 100% recollection that Mr. Sussmann said in the meeting what he also said the night before in the text message, you can conclude beyond a reasonable doubt that the false statement was made in the meeting. But that is far from all you have, ladies and gentlemen. You have a lot more to support that conclusion. What is it? Let's look at the slide of some of the evidence you've seen. Ladies and gentlemen, even if you put aside Mr. Baker, even if you didn't believe what he said, you have notes from that day from multiple people recording the lie the defendant made in that meeting. You have, as you've seen several times, Bill Priestap's notes. And what do they say? They don't say, texted me the night before. They don't say, wrote me a message. They say, said not doing this for any client. And you heard Mr. Baker testify that he spoke to Mr. Priestap immediately after the meeting about what happened in the meeting. If you credit Mr. Baker's testimony that he 100% remembers that, and that he 100% remembers that he told Bill that, you know, Mr. Sussmann made the statement in the meeting, and you also know that for other reasons. You know it because Miss Anderson, Mr. Baker's deputy, also has notes, also taken on that day, also taken in a conversation with Baker. Not a conversation he had about a text message the night before about the meeting. And Miss Anderson's notes say no specific client, just like Mr. Sussmann said in the meeting. Now, those are all sufficient reasons to conclude beyond a reasonable doubt that Sussmann lied in the meeting. But ladies and gentlemen, you have more reasons. Because you know that 5 months later, Sussmann went to the CIA. And I want to go back to Baker's testimony and look how he phrased exactly what Sussmann said in the meeting. He said, no particular client. Now, Mr. Baker wasn't at the CIA meeting. Mr. Baker didn't write or review the CIA memo, but his 100% recollection was that Sussmann said, no particular client. And what did Mr. Sussmann say to the contemporaneous memo from the CIA? Not representing a particular client. Those kinds of details, ladies and gentlemen, are what allow you to conclude that someone's recollection is genuine, that it's accurate, because it lines up with the other things that they haven't even seen. And it also convinces you that it can also convince you that he made that statement because this was obviously Sussmann's plan. He did the same thing in 2 separate meetings with the government and made that same statement. That's what happened. That is exactly what happened. And don't allow any distractions about Mr. Sussmann may have repeated it or may not have said it to distract you from the evidence. The evidence is crystal clear on this point. And ladies and gentlemen, it makes sense because when lawyers go into meetings, they have their talking points. They know what they're going to say. And his plan was the same for both of those meetings. He went in, you heard what he told Mark Chattison, the former CIA person, before the meeting he had with the client. But once he got in those government walls, he had a plan, and the plan was the same. It was to say that he wasn't there for a client. Ladies and gentlemen, there is no doubt that Mr. Sussmann said that statement in a meeting. So as Mr. Berkowitz said, let's go through all the theories of the defense and explain why it's just a magic trick to say that none of this happened. To say that none of this mattered. You know it happened. You know it mattered. The next argument Berkowitz made was that Mr. Sussmann wasn't really there on behalf of a client, saying it was nonsensical. Ladies and gentlemen, if we put the slide up again and you look at the defendant's sworn words against his words in these meetings, there's no way to reconcile those two. It was done on behalf of a client. Look at this text message, not on behalf of a client. Ladies and gentlemen, this is a powerful, accomplished lawyer, a former prosecutor. He knows how to use words. And when he says one thing under oath before Congress and another thing to two separate government agencies, one at the height of a presidential election while he's billing time to the campaign, you know that's not a mistake. You know that's not a misunderstanding. You know that's intentional. You know that's the plan. And your common sense tells you that. All of the evidence tells you that, all of it. And anything the defense says otherwise is a distraction. Now, you heard arguments that this couldn't have been on behalf of the Clinton campaign because Clinton didn't authorize it. They wouldn't have wanted it. Ladies and gentlemen, as an initial matter, I think we need to scrutinize the witnesses. Compare the witnesses who testified from the Clinton campaign, their demeanor, what they told you, to witnesses like Mr. Baker and other witnesses. Ladies and gentlemen, if we take the campaign at its word, if we take Mr. Elias and Mr. Mook at their words, they acknowledge that the best way to figure out what someone, on whose behalf someone is working when they do something, when they go to a meeting, when they make a phone call, is who they bill. It's who they bill. Mr. Elias, a top lawyer for Clinton, billing records are a reasonable way to go because lawyers track what they're doing. You look at who they bill. It's what he said. Ladies and gentlemen, look where Mr. Sussmann billed. He billed everything to the Clinton campaign. You remember the thumb drives, ladies and gentlemen? I want to focus on those. We'll come back to them, but that is damning evidence. The fact that Sussmann meets with Rodney Jaffe on September, he buys thumb drive September 13th. He meets with Jaffe the same day. He meets with Jaffe September 14th. You saw the receipt, PNY 16 gigabytes. He then gives those 16 gigabytes to Mr. Baker and then goes back to Perkins Coie. Now look at the date. When you go back to that reimbursement form for those thumb drives, look at the date on the form, September 22nd, 2016, 3 days after Sussmann's meeting. Now, I want you to think about what the campaign witnesses told you, how they might not have wanted this meeting. They might not have authorized it. But think to yourself, and oftentimes in life, it's when we spend a big effort on a little thing that's most revealing about our state of mind. Mr. Sussmann took the time 3 days after that meeting to bill the thumb drives that were probably no more than $15 to the Clinton campaign. Why would you do that unless you thought you had been at the meeting for the Clinton campaign? Why would you take that effort? Why would you do that at all? And if the campaign had made clear to Sussmann by that point that they didn't authorize this, that they didn't want it, Mr. Elias said that he was notified either shortly before or shortly after that meeting. He thinks that Mr. Sussmann was going to do this. Well, if it was shortly before, nothing was said to keep him from going. And if it was shortly after, it didn't stop Mr. Sussmann from them billing less than $15 to the Clinton campaign. Again, when you put that much effort into a small thing, it says a lot about your state of mind. It says a lot about who Mr. Sussmann thought he was working for. Now, you heard some arguments about how the billing entry for that meeting was vague and how you can't tell because Mr. Sussmann would have said meeting with the FBI. He would have noted this in his billing entries. Now, you'll see the defendant's billing entries. They are, in some cases, imprecise. In some cases, they're vague. And ladies and gentlemen, let's look, for example. We talked about the thumb drives. We talked about this meeting with Jaffe on the 13th. Now, if you put the pieces together in context with the other evidence, you know what was happening on the 13th before that meeting because he's getting ready to go to the FBI. He's been billing, quote, drafting of a white paper. You know what white paper he's talking about to the campaign. And he meets with Jaffe both on the 13th and the 14th. And you know, because your common sense tells you, they're getting the materials ready for the FBI. They're loading the thumb drives. They're gathering the data. They're gathering the 3 white papers that they gave to the FBI. And how does Sussmann build the September 13th meeting with Jaffe? We look together at the exhibits. It says meeting with R, meeting with Rodney, work regarding confidential projects. So that right there, ladies and gentlemen, destroys any argument by the defense that just because there was a vague billing entry, Mr. Sussmann didn't think his meeting was for the Clinton campaign. Mr. Sussmann obviously thought the meeting was for the Clinton campaign because he billed the time for it. And then 3 days later, he got himself reimbursed for the very thumb drives that he handed to Baker. So, ladies and gentlemen, those are the kinds of things that as the defense rattles through arguments, you have to pause and consider and apply your common sense. And ladies and gentlemen, again, it is the government's burden. The defense has no burden to put on evidence. They have no burden to present any affirmative defense. But when they do present arguments, you need to scrutinize those arguments and compare them to the evidence. And on each and every argument they've made, you will see the arguments don't hold up. Now, ladies and gentlemen, we've heard a lot about this 13-minute phone call. The defense's argument there is that a 13-minute phone call between Baker and Sussmann in September, a few days after the meeting in September, that Sussmann must have told Baker he had a client. Because what else would they talk about on a 13-minute call? You know, that is a huge leap that is not supported by any evidence. And that was exactly my point before this rebuttal. Ladies and gentlemen, first of all, Mr. Sussmann and Baker were friends. Nothing about a fact of a 13-minute call supports the argument that Sussmann mentioned a client. But, you know, he didn't mention a client for a couple of reasons. First, let's look at their text exchanges after that call. We go to Exhibit 1500. This is after their call in which Baker says, Mr. Sussmann, you didn't tell me who the reporter from the New York Times was. Could you tell me? And Sussmann didn't disclose and doesn't disclose who it is in the first meeting. He's hesitant after that call. He's got to check. But what does he say? What are the words that he uses? Jim, sorry I've been unable to respond sooner. Travel plans and person's availability were not ideal this evening. Now, ladies and gentlemen, we know now that the person he had to check with was Rodney Jaffe. He needed to go back and see if Rodney Jaffe was okay giving Eric Lichtblau's name, the New York Times reporter. But there's a very intentional use of a name here. He doesn't say travel and clients availability. What he would say, which is what he would say if they had a call talked about a client. He says person's availability, not client. Person, the person. Now, I don't know about you. I've never heard of an attorney-person privilege or an attorney-person relationship. You say attorney-client. This was an intentional effort by Sussmann to continue his lie, to continue to mislead Mr. Baker into thinking he didn't have a client and that he had person or persons. Ladies and gentlemen, that text message right there refutes the notion that any client was disclosed on the call. And it also refuted by the fact of the meeting 5 months later with the CIA when Mr. Sussmann tells the same lie. And so, ladies and gentlemen, you can see how on an initial, when you first hear one of the defendant's arguments, comes at you quickly. It might make some initial sense. It might start to create doubt in your mind. But when you look through the evidence, when you look through the testimony, when you look through what actually happened, it's all going to make sense. And the way it makes sense is that Mr. Sussmann made a false statement. He made that statement because he had reason to do so and because he wanted to achieve a certain effect. Now, why did Sussmann make that false statement? You've heard many arguments about this, ladies and gentlemen, suggest that this lie, even if it happened, it did no harm and no foul because the FBI knew that he was a DNC lawyer. Everybody knew that Sussmann was working for the Clinton campaign, but you have to think about how words matter. You have to think about what they actually knew. They knew Sussmann was a DNC cyber lawyer. They knew him as a lawyer who represented a number of different victims and hacks. That's why he worked at the cyber division. And I want you to go back to the evidence. When you go to deliberate and look for an exhibit, look for testimony, look for a document where anyone at the FBI says that they knew Sussmann worked with political campaigns. You're not going to find that because they didn't know. They thought of him as a cyber lawyer, as someone who represented victims of hacks, not the kind of person you might suggest would bring in or suspect would bring in opposition research. Ladies and gentlemen, of course, everybody knows who the DNC is. Most people know. Everyone at the time knew who Clinton was. You saw a chart from the defense, both from Berkowitz and from their summary witness, poor Brandon. They put this chart together to argue to you that, look at these blue colors. They show you that Mr. Sussmann was a known DNC Clinton campaign lawyer at the FBI, and anything he said, any lie he told, couldn't have mattered because they knew it all. Ladies and gentlemen, it is exactly because the defendant knew that people affiliated him with the DNC that he had to lie. That's why he lied in the first place. It was the motive for his lie, ladies and gentlemen, because he had to lull Mr. Baker away from the notion that these allegations might be sponsored by political entities. He wanted to create the false impression that this was neutral and it was just computer scientists who stumbled upon the data. But that is motive, ladies and gentlemen, and the defense has seized on a number of text messages and emails within the FBI where you do see individuals referring to him as a DNC attorney or a Clinton attorney. But ladies and gentlemen, you know exactly how that happened. It's not that those people knew he was there as a political hack and decided it didn't matter. It all starts with Baker's notes. And if we look at Baker's notes, you see on the left, it says represents the DNC and the Clinton Foundation. You remember Baker telling you that he was situating Mr. Priestep in that situation, in that discussion. He wasn't saying Michael Sussmann came in with a bunch of opposition research and this seems shady. He says, I was explaining to Priestep and Sussmann represented the DNC and the Clinton campaign. That's how they thought of him at the FBI. Ladies and gentlemen, you see on the right something the defense showed you where an FBI agent says exactly what Mr. Baker said in his notes, essentially a lawyer representing the DNC and Clinton. In other words, the DNC and Clinton's lawyer brought something to the government, not that he came to the government as political opposition. So once again, ladies and gentlemen, the defendant's arguments confuse. They want you to think, they want to convince you that none of this mattered, that this was a harmless lie. And that if you come in and tell the FBI you're there for the Clinton campaign and they know that you've represented them on some other matters, it's no harm, no foul if you come in to provide opposition research and spur an investigation weeks before the election. But once again, ladies and gentlemen, your common sense tells you why that is not the case. You've heard lots of arguments about materiality, and keep this in mind. I want you to follow very closely Judge Cooper's instructions on materiality. There are two components to that. A statement is material if it has a natural tendency to influence or is capable of influencing the FBI. You've heard arguments from the defense to suggest, as I was just describing, that, look, it wouldn't have mattered. The FBI would have investigated this as they did anyways, saying the lie didn't matter. But there's another part of the instruction as well. Proof of actual reliance is not required. Keep those instructions in mind. Materiality, he says, as a requirement is intended as instructions to weed out the trivial lies, things that don't matter, things that aren't relevant and don't affect decision making. That's not the kind of lie Sussmann told here. His lie was material. And now let's take Mr. Berkowitz's arguments and break them down. He told you that this wouldn't have affected the investigation because it was technical data and they would have done the same thing regardless. But that's not what the testimony says. Let's look at Mr. Sussmann's text the night before. This isn't the lie the defendant is charged with. He's charged with the lie in the meeting the next day, but it's the same lie he told that same night. And let's see what the Bureau actually did, because in order to determine if something is capable of influencing the FBI, you got to look at the FBI. We have a meeting on September 19th. After they met, the FBI opened an investigation and they decided to open a full investigation. You remember the differences between preliminary and full? FBI opened a full investigation from the very beginning. Before they charged the false statement, or before it was even made, you know it was material because Jim Baker said that in the text message the night before. Baker testified that he would have immediately had conversations with senior leadership if they should have even moved on this, if he had known that he was coming on behalf of a client. Baker said that he was getting data. He didn't know where it came from, and if he gained some inkling about where it was coming from, he would need to examine legal issues. That would have taken time. That would have pushed things down a different road. That's affecting the function of the FBI. And what else did you hear? Take more time. Mr. Baker said something to the effect of, we would have slowed this down because you remember seeing text messages and emails. The director's fired up. The FBI's fired up on this. They were fired up because Mr. Sussmann came in as a credible attorney working with his cyber credentials. That's affecting the function of a government agency. And you also heard Mr. Baker say, look, if I knew this was for a client, a paid client, a political campaign, or a business or representative of a business, I wouldn't have done this meeting alone. I would have pulled in somebody else, an agent, somebody to help him in the meeting. And how would things have gone if you had an agent there trained in interviews? Maybe you have notes. Things might have been different. It might not have moved forward. Things may not have gotten this far. Ladies and gentlemen, you heard Mr. Baker and countless other witnesses tell you that Sussman's lies concealed, in part, was that Jaffe was behind the allegation. And every witness who was asked this question said it would have been highly important to know why confidential human sources have FBI handlers, and FBI handlers have to go through the proper channels. Special Agent Curtis Heide described another instance in this investigation. He told you that in this case, there was someone who came to the FBI and was openly politically affiliated. And what did Heide say he did there? Did an interview and they ended it. Okay, so he's comparing and contrasting. That very likely may have happened here as well. If Sussmann may have told, in other words, all of these things could have and likely would have happened, would not have happened if he had been honest. All of this, ladies and gentlemen, is before the investigation even starts. But let's play this exercise forward. In light of all those factors, in light of all the different things that could have happened if Sussmann had told the truth, the FBI may have never even investigated this at all. But let's say it did. Once again, the FBI could have opened just a preliminary investigation, which is kind of in the middle category. It might have taken a more modest approach, saying you heard testimony that the credibility of the allegation, the likelihood that it's true, affects the investigation that is put on. We also heard from Gaynor and some others. Ladies and gentlemen, you heard testimony from Sands. She was getting into the office at 6 a.m. and staying there till 6 p.m. at night. People at headquarters were spun up about this. People in the field were working day and night on it. If Sussmann had told the truth, the FBI, even if it opened an investigation, might have devoted fewer resources. It might not have taken this as far. So in considering materiality, ladies and gentlemen, if any one of these decisions might have been different, if any one of these branches might have been followed, if any one of these forks in the road might have been different, it's material. And if any one of these might have been played out in a different way, that is material. Ladies and gentlemen, there is overwhelming proof here that the defendant lied on September 19th and that it was material. But now we have to talk about intentional. In other words, why did he tell that lie? You heard other evidence in the case that it was only part of an effort. We heard from Agent Grasso, who knew Jaffe. You saw Grasso was asked about circular reporting. We also know that Jaffe was a confidential human source. And there were emails from Grasso and Jaffe and others. You also heard testimony that it wasn't part of the plan to get the FBI to investigate or get the FBI to cause a news story. But ladies and gentlemen, your common sense tells you that's exactly what the plan was. If you look at the date of these emails, there's an email from a reporter, and you heard testimony from these people and public affairs officers. Ladies and gentlemen, you saw communications between reporters and Fusion GPS urging them to run the stories. Can there be any doubt, ladies and gentlemen, that the plan here was to give information to the FBI, give the information to the media, and then cause the media to write about an FBI investigation? You have it in an email here to the FBI. And you'll remember, if you look at Sussmann's testimony from Congress, he said that he gave Alpha Bank allegations to Ellen Nakashima and Eric Lichtblau. They were communicating all this time with Sussmann. And let's go back to the reporter. He's urging the FBI to give him information on this. He's saying he knows that it's under careful investigation. You can see what the plan was here. You can see what the motive was here. It was to create an October surprise by giving information to both the media and the FBI to get the media to write that there was an FBI investigation. And that is why, ladies and gentlemen, when Mr. Sussmann went to the FBI, he said he wasn't doing it for a client. Because if the public were to know that this was all circular reporting, that the very things that they were reading were coming from Jaffe in the campaign, it would have gravely undermined the credibility of their allegations. If you have heard testimony about how the FBI handled this investigation. You've seen the FBI didn't necessarily do everything right here. They missed opportunities. They made mistakes. They even kept information to themselves. That is not relevant, though, to your evaluation of the defendant's lie. It's not relevant to your evaluation of whether that lie was material because, ladies and gentlemen, the folks in the field knew it was material. You saw Curtis Heide, an email saying, we really want to interview the sources. We really want to know where it's coming from. We really would do this in any other investigation. And the judge is like, hey, Mr. DeFilippis, It's Memorial Day weekend. I've got a vacation to go to. There's a beach house waiting for me. My wife's going to kill me. Let's wrap it up. Prosecutor says, yes, okay. And he's going to max out his time, certainly. Good call. And so, ladies and gentlemen, the fact that the FBI made mistakes here, the fact that the FBI might have handled this in a way that you wouldn't have handled it, should have no bearing. And let me end with this. The government has said throughout this trial that this case is about privilege. You've heard a lot about privilege of a lawyer who thought he had a license to lie. Lawyer with a license to lie. That's some good alliteration there. You've heard about the privilege of a technology executive who used sensitive access to conduct opposition research. You've also heard about attorney-client privilege. Today, you have a different kind of privilege. You will have the privilege and the very weighty obligation to render a fair and just verdict based on the evidence, the law, and the truth. The defense started talking about the Statue of Liberty. And I want you to think about the Statue of Liberty, Lady Liberty, holding her arm up high. Your guiding torch in that jury deliberation room is the truth and the evidence and nothing else. Under the law, no one has a license to lie to the FBI. Under the law, having the FBI general counsel in your phone contacts does not exempt you from the truth. Under the law, no one is entitled to make a false statement to weaponize a law enforcement agency in support of a political agenda. Not Republicans, not Democrats, not anyone. Ladies and gentlemen, this case is not about politics. It's not about conspiracies. It's about the truth. And when you came into this courtroom and raised your right hand, you swore to apply the law fairly. As Judge Cooper instructed you, that means you should not and cannot be influenced in your deliberations by anyone's race, ethnic origin, gender, or political views, including your own. Now, in just a few minutes, it's going to be your time to deliberate. It has been an honor and a privilege to present the evidence to you in this trial. And as you go back to the deliberation room, I'm going to quickly ask you to do three things. First, carefully consider the evidence, the actual evidence in this case. Second, follow Judge Cooper's instructions on the law, and the instructions that you have. And third, use your common sense. Don't abandon it. The same common sense you use every day in your lives. If you do those three things, I'm confident you will reach the one and only verdict that's consistent with the law, consistent with the evidence, consistent with the truth, which is the defendant is guilty as charged. Thank you. Judge says, thank you, Mr. DeFilippis. Ladies and gentlemen, before you retire for your deliberations, I have a few minutes of concluding instructions for you. First, says Judge Cooper, a verdict must represent the considered judgment of each juror. And in order to return a verdict, you must agree. In other words, your verdict must be unanimous. Use your jury form. Nothing in the form replaces the law. We're going to send you into the jury room with the exhibits. You may examine all of them at your leisure. Please keep in mind that anything not admitted, yes, okay. When you return the verdict, when you return to the jury room, probably the first thing you're going to do is eat lunch. But after that, the first thing you should do is select a four-person. No specific rules about how to do this, but you only have one mission: reach a fair and just verdict. Don't consider the question of punishment. That's something I'm going to do. I know that I've reminded you throughout not to do any research. Don't look at any media coverage or watch people's YouTube channels. And if any publicity about this trial comes to your attention, do not discuss it with anybody else. As you retire to deliberate, I also wish to remind you, don't do any independent research. If you need to communicate with me, write a note and I will take it. Bear in mind that you're never under any circumstances to reveal any person how the jurors are voting until it's been voted. The attitude and the conduct of the jurors is very important. The last thing I want to do is, and I must do this before you begin, is a task that I take no joy in at all. The judge is about to bring the hammer down. And I will apologize for having to do it, but that is to excuse the alternate jurors in the case. I know that it is frustrating to sit through 2 weeks of evidence and to sacrifice your time and then be told to go home. But as I told you before, it's nothing personal. We selected 4 seats to be the alternates. And so, dun, 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 jurors number 1 and 6 and 10, you're out of here. And I don't know what jurors those are. We haven't been able to corroborate who is what number. But before you leave, I'm going to ask you to make sure that Miss Calloway has your information because we might need you back if something happens. My earlier instruction of don't use the internet applies. Thank you for your service. Before you reach a verdict, send me a note. Now, he says, this is funny, the judge says, now I have to be out of the building this afternoon, unfortunately. I told you, vacation. His wife's like, we're leaving on time this time. You said the last trial that we were going to leave at 2 and we didn't leave at 2. And I almost divorced you over that. And he's like, all right, relax. So I will not be in a position to answer any substantive notes that you may have this afternoon or to accept any verdict that you might reach. But as we've discussed, I would like for you to begin your deliberations so that we have slack time this week if you're comfortably doing that. So he sent them back and he left. He's on the beach already. The jurors, they were there till 5 o'clock. They're like, this stinking judge. He's not even going to sit here in his chambers. We're on our own. He says, all right, ladies and gentlemen, you're going to have 3 days off. You know, in addition to this, we're still in a pandemic. So look, don't go out there and catch COVID because I need you back here on Tuesday. So with that in mind, Calloway is going to escort you out. And the court says, after the jurors leave, he says, whew, all right, ladies and gentlemen, we can let our hair down now. Woo, man, woo. He starts cracking open the tequila and he says, all right, please be seated, everybody. Congratulations, says Cooper. Well tried, both sides. I'll be available by phone this afternoon if some, the routine, logistical issues come up. We'll bring them back on Tuesday morning. Let them know they can come straight back to the deliberation room and they can start and don't start deliberating until all 12 are present. Anything else, you guys? It's time to go. Not from the government, Your Honor. Berkowitz says, Your Honor, is it your intention to have them deliberate until 5, or are you going to just excuse them when you leave? He says, well, given that we're not taking any notes, he says, I think that we should just give it, I'm not going to make him stay Friday for a long weekend. Cut it off at 5. And in the unlikely event they reach a verdict, would you have them hold it? He says, I know it's unlikely, but I want to ask. He says, I would like to take the verdict, so we would not likely have it until Tuesday. Thank you very much. Oh, Berkowitz is here, lapping it up as typical defense lawyer. Great. Thank you very much, Your Honor. We appreciate all that you've done for both sides during this. We very much appreciate it. And the prosecutor's just like, I'm out of here. Like, see ya. It's like, Friday, I'm out of here. Bye. The defense lawyer's like, we appreciate you. You're a great guy. Beautifully done. Nice oration here. Court says, oh, my pleasure. And Tuesday, when we come back, I don't know if you have arrangements in the courthouse, but either stay in the courthouse or someplace close. And understood? All right. And that's it. That's the Sussmann trial. We made it. Woo! 10 days. And we did transcripts the whole time and we got through the entire stinking thing. It is now back at deliberations with the jurors. And my goodness, shout out to everybody who was able to hang with us throughout this entire trial. We read a lot of transcripts here. And this was all possible from our court reporters, Lisa. We have a morning Lisa, a nighttime Lisa. We have a nighttime Lorraine, and we have a nighttime Nancy. So we also want to shout out to all of our amazing court reporters because, woo, that was a lot. That was a lot. That's a pretty big trial. And let's take a look at the mind map. Let's zoom out on this thing and see what we've assembled here. It's our team approach here on this thing. Let's see. Here is the mind map. We're zooming all out on this thing, and I'm as far zoomed out as I can get. I can't even zoom out any further. It's like that scene out of Super Troopers. Like, pull over further. I can't pull over any farther. It's like, this is it. We're zoomed out, max capacity. So we can see, we can close this up. We've got day 8, day 9. We've got day 10, jury deliberations. We can see we've covered 10 full days of trial here. And we started with jury selection. Probably a good time to take a look at the jury, by the way. We remember when we went through jury selection, I was able to tease out data about 10 of them. I don't know what happened to the other 2. They were playing this game of musical chairs, and I lost track of... We may not have even gotten questions on some of these people. I don't know. But as a quick refresher, the jury is somewhat interesting. We have this woman here, a Treasury Department DNC primary donor. If we take a look at this, the line of questioning was, very quickly, the questionnaire juror, you mentioned that you had donated to a 2016 presidential campaign. Is that right? Juror said, primaries. Oh, the primaries. Who did you donate to? He says, well, it would have been on the Democratic side. Okay, that's fine. Nobody here is on trial who was a Democratic primary person. So that juror got on there, right? So somebody who donated to the DNC. This lady was also a Democratic donor. Prosecutor asks, you also mentioned that you donated some money to the candidates. prospective juror. So I think I started to write that, and I actually believe it was for the 2020 election. I can't remember if I made a donation in 2016. I did support one candidate over the other, but I don't recall if I made an actual donation. I don't think I did that year, but I'm sure that I did in 2020. I think you said you likely donated to Hillary. Juror says, had I donated to a client, that's how I would have done it. Oh, okay, so you got another lefty on there. And then probably the most damning juror for the prosecution is this one. And again, she may have gotten booted. I don't know because we can't see anything. Or actually, we wouldn't be able to see it anyways. But typically, well, even the media and people will sort of help you assemble the jury box, the panel, the jury seat box. And we haven't been able to really get anybody in there. Anyways, this juror was the older woman who worked at the Smithsonian, a history professor or something like that, says, ma'am, you talked about the 2016 election, and obviously people have strong feelings about both candidates, right? Yeah. You answered that you strongly dislike Mr. Trump. She says, and? He says, and that you're not sure you could be impartial. She says, yeah. If this was someone on his team or something, then yeah. So this is not, he says, neither Mr. Trump nor Ms. Clinton are on trial here. You'll hear their names and you'll hear about them. And she made it on until she may have gotten booted, right? So strong dislike for Mr. Trump. No real Republicans. This person works for the Peace Corps. This guy's a government contractor. This maybe is a Republican, maybe person. This juror's father is somebody who used to work on the Senate Foreign Relations Committee over at the CIA. And there was some question about some CIA testimony and whether that might matter or not. And so he worked for Senator Corker, who I think was a Republican. So maybe conservative. I don't know. Otherwise, we have a mechanic, a 25-year-old, I think, who likes to play Elden Ring. How old are you, sir? 25. It says here you like to play video games. Young man, is that true? That's correct. What's your favorite game? Favorite one is probably Elden Ring. I'm sorry. One more time, said the judge. Elden Ring, said the 25-year-old. Judge says, okay, the lawyers may know more what that is. I don't know. Says, have you heard anything about this case? No, I haven't heard anything. What's the first thing that came to your mind when I brought this up? Nothing, really, is what he said. So that's the jury. He's probably going to be pretty neutral. Otherwise, we've got a medical illustrator, and then we have a gymnast and a teacher. So that's the jury. There are 10 people there. There were 2 that I couldn't really gather because I got all of this from voir dire, right, which was the original round, the initial round of questioning before it... before they actually drew the names, essentially. So that is it, my friends. That is the full mind map. And I want to pause and say thank you to all the super chats that came in to support our transcript fund because we ran through a lot of transcripts. And I don't know what the total damage was on all of them, but we're not done yet. I mean, there's going to be questions and there'll be some more transcripts, but they'll be short. They're not, full days of testimony. But we couldn't have done it without each and every one of you supporting the work that we do. And so I'm grateful for that. And I want to say thank you to the super chats that came in. And we're going to start off with, we had Patricia Nab at the start of the show with a very generous dono. We read that one talking about, did the prosecution enter that testimony as evidence? And they did actually, right? We read through some of that today because they referenced it in both closing arguments. The government said, see, he's a liar. The defense said, see, he's not a liar. And they both picked out different portions of the testimony. And so we'll see what the jurors say about it. I think the evidence is pretty overwhelming. I agree with the prosecutor on this. Mary Briggs gave us some beer and transcript money. Thank you for the dono there, Mary Briggs. Tina Johnson brought another one in, said, appreciate all that you're doing here. I pray that the disruptions to our free speech and elections will be captured. I agree with you. I would love to see some something to stop this type of stuff from happening on both sides. I mean, I really don't think that anybody should be using the government to gain favor over anybody in any way, shape, or form. I'd like to see the government really, kind of cut down to size, actually, so that they can't do that anyways. But here, Anthony Henson says, thanks for the excellent work with another dono. Thank you, Anthony Henson. Andrew Passman says, these jurors from D.C. are probably going to end up in a hung jury due to their environment. If they do you think the next trial will allow for even more damning evidence to come out exposing all of them on all sides? So, I'm not so sure because if there's another trial, many of the evidentiary rulings they've already ruled on them. And so would there be any major changes? Did we learn anything new that would lead to like new indictments? Like, did Mark Elias say anything that they're going to indict him over? Not really. I mean, it was probably not, maybe, but probably not. It was a whole bunch of I don't remembers. What I'm interested in is the additional prosecutions, the continuation of this. Where does this mind map go from here, right? All of this was really just sort of one, right? This was one trial. This is John Durham. This is Hillary Clinton. This is Perkins Coie. But we know that within Perkins Coie, there was all sorts of just really nefarious stuff going on. And we can close this out, right? We had just this. This is really what this trial was about. This one meeting. But there are all sorts of other actors in here. And there were other people who worked on it. We haven't seen any, sort of evidence that they're going to be prosecuting anybody else, but some speculation from others has been that it's going to be, if it were to go further, that they'd be looking at people like Peter Strzok and Andy McCabe and some other people who were there at the FBI, who, in my opinion, were colluding in this entire scheme. We'll see. That was from Tammy Beck. No, that was from Andrew Passman. Tammy Beck says, hoping for a conviction. Thank you for all you've done over the past 2 weeks. Thank you, Tammy. And I appreciate you being here and supporting the program here. Like I said, wouldn't be able to do it without you. Kim Ari Niello says, let's go, Brandon. And Brandon was really probably the government's best witness. And he wasn't even the government's witness. He was the defense witness over from Latham and Watkins. And it was hard to gather really what he was doing with all those colors. Remember yesterday we talked about the light blue, the dark blue, and the medium blue. And he had them all organized on this big chart, this kind of big spreadsheet that he was showing up there. And I think it was supposed to be colorful. It was supposed to be like a lot of activity in order to make the argument that he was communicating all over the place, with all sorts of different clients in order to kind of confuse the jury. But I don't think it landed at all. I mean, when he got up there yesterday and said, I never even heard of that date, I think that was pretty bad. And so I just don't think it landed as well as it could have. Kathy Whitner became a member on YouTube. Shout out. Welcome, Kathy. Appreciate that. Shelly says, if not the Russians, who really hacked the DNC server? Assange knows. Hashtag rest in peace, Seth Rich. Yeah, I mean, that's what many people are talking. Was it really a hack? Like, was it a hack, or did somebody just kind of say, here you go, did kind of leak it out? Did somebody crack into it, or did somebody just sort of take the information out, and sort of asking those very important questions? We have another one. A couple came in. Kathy Whitner with another dono. No question on that one. Thank you, Kathy. Susie Witt says, thank you. Very easy. Thank you, Susie. I appreciate that. Super chat transcript dono. Oil Smoke Jones says, too bad J6 stuff is verboten. Lots of legal atrocity there, begging for your uniquely capable analytical gift. So Oil Smoke Jones, I mean, we're going to be switching over there pretty soon. Steve Bannon, I think, is scheduled for trial in July. I don't know what date it is. We also know that Ghislaine Maxwell has her sentencing proceedings coming up here pretty soon. We'll see if there's anything there. But the J6 stuff, I mean, hopefully we start to see some activity on that. Like, I'd like to see if we're going to have this fake January 6th select committee prosecuting all of these things, let's see. Let's get some trials going. Let's see the subpoenas. I want to go through it. And we are scheduled for Bannon. He might be the very first one. We'll see. But yeah, we're going to switch over to J6 because that's also a huge, gigantic scam. The January 6th Select Committee, more specifically. I also have major issues with the DOJ and most of those January 6th prosecutions. We have covered a lot of the J6 stuff. The problem with some of the J6 stuff, it is a little bit verboten on YouTube. I think that it doesn't fit neatly within a category, but there are several categories that can apply to it. So, but we will continue to cover it. I mean, the more and more we get away from the actual J6 event, we can absolutely talk about like the prosecutions and all of that. It gets dicey when you start talking about, the election is really where YouTube has a problem with it. Chris DeBayer says, brilliant coverage, so important. Trust you get a refreshing beverage for your parchment. Let's do that right now, Sean. We don't want parchment to become parchment or to be parched, because then you might become parchment. Cheers on the drinks. Almost out on that one. Here we have Ordrock says, dono for the paper trove. Keep up the great work. Scott Pasteur out here in Southern Oregon again. Shout out to Scott in Oregon. When I stationed in Yuma, I never owned a pair of trousers. except my uniform. Semper Fidelis from Ordoc, who's out there in Southern Oregon. And, you know, I've been to Oregon. I think it's a beautiful country. There was some conversation about Oregon and like Washington and like the greater Idaho movement to sort of leave many of these liberal states and join Red America. And so maybe that's what's happening in Southern Oregon. I'm not sure about that, but that was from Ordrock. Let's Go says, seriously, I can't pay attention. Ready the chat. I'm sure you're amazing, Tob, but it's off the chain in the chat. Oh, so I was, so it's really hard when I'm reading this to like pay attention to the chat. So I like miss it. I like, you guys, maybe you might be just having a whole separate conversation, maybe not even listening to what we're talking. I don't know, but it's hard to read. So I don't really know what was going on, but thank you for the heads up there. Let's Go. I'm sure you're amazing, to be honest, but it's off the chain in the chat. It's probably a better show. It's probably more interesting, to be honest, but I'm glad. Thanks for the heads up. KNT says, thanks for all the hard working. And thank you, KNT, for supporting the program, supporting the show. 420 Headies here with a super chat dono. Bad Bob also with a super chat says, thanks, Rob, for what you do. Thank you, Bad Bob. I appreciate you for being here and doing what you do. Zulu says, thanks for doing this every day while mainstream LawTube spoon feeds mainstream cotton candy to mainstream minds for clicks. God, that's a lot. Zulu, first of all, A+, like that's amazing alliteration there. Mainstream minds for clicks, mainstream LawTube. I love it. Good cadence. It's good. It's good. In Shakespeare, you talk about the iambic pentameter. Remember that? It's sort of a way you structure sentence with good cadence. It's not really alliteration there, but there's good cadence. Mainstream minds for clicks. It's good cadence. I like it. Anyways, back to the underlying story. Yeah, look, the whole whole trial has really turned into something, hasn't it? I mean, it really has turned into something, and I'm having a hard time keeping track of what the heck is going on, to be honest. I don't really even know what's going on with most of that, but we are just covering Sussmann, and we're just going to keep our heads grinding away at this. But yeah, that has turned into a whole kind of beast of itself, in and of itself, hasn't it? The whole trial and what's going on with that. But, you know, I know that a lot of people are interested in it. I know that a lot of time has been spent sort of invested in it, and a lot of people are really anxious to get a verdict. And so I hope they're relieved and satisfied with whatever comes out of that. I don't even know what it is. All right, but that's from Zulu. Thank you, Zulu, for being here. Thanks for supporting the show and for joining us as we do, you know, some heavy lifting, reading the transcripts, and we'll continue to do that, I think. We have Lori Chavez is here, says, thanks for all you do. Thank you, Lori. Robert Barnes became a member. Is that the Robert Barnes? The Robert Barnes? I don't know if it is or not, but I'm going to have to check. And since he's a member, I guess he's going to see everything that happens behind our membership community, which is, we'll have to see what his opinion is on that. Shout out to Robert Barnes becoming a member. Kay Scott is here, says, please tell us your opinion. Is it going to be guilty or not guilty, and why? So I'll tell you this. Earlier on the program, or early on in the day, I was a little bit concerned. I was telling a friend I was a little bit nervous. I'm like, I'm a little bit nervous about this. Why? Because the DC jurors, and, you know, it's really hard to overcome, I think, political cognitive dissonance. Like, you'll see people, I mean, think about what we've lived through, like the last 2 years, 3 years, whether it's Russia or COVID or, you know, Supreme Court abortion opinions or whatever. You know, it's always like, we see a contingent of a certain political demographic that will do everything possible to twist themselves into pretzels in order to conform their underlying base values into like this new, fit it into this new movement, whatever it is, right? So it's like COVID now. And then we get a bunch of people that are like COVID experts who want to pass all sorts of policy and like change everything so that they can feel safe. Okay. Then, you know, Elon wants to buy Twitter. Same thing. Bunch of free speech advocates. Everybody knows how to solve this problem, and they're going to do it all better than everything. And now free speech is at stake. New gun crimes. Okay. Everybody's an expert, and they're all going to come in here and they're going to, you know, pass new laws and new regulations and new rules and all those things. And it continues to sort of spiral out of control in that way. So they make themselves fit into that new sort of ideology. There's this new cause, and they sort of work backwards. I'm going to be a part of this cause, and I'm going to go make it work. My underlying values, I'll make them fit into this new narrative. And so you get some jurors there who can just do the same thing. They can just say, well, look, I know that all this evidence was bad, but it was to stop Putin. Yes, I know it's all true. This guy's probably a liar, but he acted in good faith because he was trying to stop Trump. Okay. And you see, right? People, hey, man, look, I didn't think that we were going to be living in a country where a huge portion of our own fellow citizens were going to be screaming at us to lock ourselves in our homes and then like justify themselves for that, right? Remember how many conversations we had with many of our friends and family? I know you had them too, where you're like, do you think this is a good idea? Do you think this is like a reasonable thing to be doing here for like the future freedom of America and all this? Like, is this appropriate to give our government this power? And people were just like, absolutely. What kind of person are you? You want to kill grandma? You think that your right to live is better than other people's right to live and all this crap. And you go, bro, like 6 months ago, you were somebody who like used to believe in the Constitution and used to say like certain things, and people were flipping all over the place. Republicans and conservatives and everybody was just losing their stinking minds, bending over because they were scared and petrified. And so you start to ask yourself about those people. Are they anchored into any real, are they moored into any real hardcore first principle values, anchored down? If you can just sort of say freedom matters until I'm scared and then it doesn't matter. In order to justify that, right? Like those people don't think of themselves that way. They don't think of themselves as people who disagree with themselves. They think they have internal consistency. They think that they're freedom-loving people, but now freedom has changed a little bit because we're facing a new challenge. So you go, okay, right? People were saying the CDC had power to take people's private property away from them, saying you have to put a piece of cloth on your face, all sorts of, crazy. And that's just on one example. Same thing with schools now. And the Second Amendment doesn't matter anymore. And all of these things, one after the other, after the other. So now it's a very simple conversation. You have a juror who happens to be a hardcore Democrat who hates Donald Trump, who sees these arguments being made, who does the same mental gymnastics, twisting themselves into pretzels to make this fit. Because if they don't make it fit, there's going to be some serious cognitive dissonance and they are not going to feel good about themselves. So they're going to thread the needle, right? And now I was feeling a little bit nervous about that to sort of wrap this comment up. But it, I think, has been slightly alleviated here based on these closing arguments. I really do not think that the closing arguments and I'm just sort of shooting from the hip off my quick read that we went through there, but I don't think that Berkowitz's closing argument really instilled a lot of confidence. I think he was asking the jurors to fill in an alternative theory that he didn't give them enough on. The prosecution is right? If I say the defense has to put forward a theory, that's a little bit of what's called burden shifting, right? The defense doesn't have to do anything. I've made this point many times here on this channel covering criminal cases that the defense can just sit there on their hands and not say anything. It's the government's burden to prove it guilty beyond a reasonable doubt. If the defense doesn't say a thing and the government fails their burden, that's fine. When you start to say, if I start to say, well, the defense should have made a showing of some sort, that is burden shifting. That's not what I'm talking about. I'm not saying that they have to disprove the charges, but I am saying it's useful to kind of shove up a shiny object in front of the jurors and say, look at this. This is the alternative theory. I know that you don't want to convict Sussmann, and I'm going to give you this fake because that you can use as a justification to not convict him. And I was waiting to see what that shiny object was. What are they showing us? What is Berkowitz going to do and say about those billing records and about all of those emails and all these phone calls and all of this stuff? And what he delivered wasn't all that great. I mean, if I got to be honest about it. He lied on the 18th, therefore he didn't lie on the 19th. Not that great. He had a call on a couple days after the FBI meeting where it was a 13-minute call, and that's when he explained he had a client, right? I don't buy it. I mean, and I'm seeing it as a defense attorney, and I'm like, all right, I don't think it's enough there to sort of give the jurors something on which they can hang their hat. So it is, we'll see. I really think that the prosecution, their closing argument brought together the case nicely. I thought it was very nicely organized. I noticed that they didn't say They didn't use their opening theme. Remember, they ditched that theme somewhere in the trial. The opening theme was a look, a leak, and a lie. They came out, they had the 3 alliteration, a look, a leak, and a lie. Now, if they were really hammering that home, they would have brought that back full circle in closing. Well, we didn't really see that throughout the trial. I think they probably tried it on and they looked at the jurors and they're like, they don't get this. They don't like it at all. And so they ditched it. But they kind of changed courses, and I think it was a pretty nice closing argument. Pretty standard, right? Prosecutorial closing arguments are pretty standard, right? It's very scripted, and they've got 2 cracks at it. And so the defense, oftentimes in defense closing arguments, it does feel just naturally. And even when I've been giving them, it's sort of like it is a kitchen sink approach. You have a lot less time to prepare your closing because they go and you got to respond to what they say. And you're also trying to anticipate the rebuttal close. And so you're like, you just kind of are writing real quickly. What did he say? What did he say? I'm going to address that, address that, address that, address that, address that, in addition to your main close, right? You have your points you want to make, but you don't have any other additional rebuttal time. The government gets 2 cracks. So you got to address their rebuttals and anticipate the other rebuttals. And so oftentimes it feels very disorganized and sort of scattershot. And that's what I saw when I was reading Berkowitz. But he's still very good, right? He hit everything in the kitchen sink. And I really think he gave the best alternative explanation for that meeting and for the phone calls that he could, but I don't think it really sticks. So I would say guilty or a hung jury. I mean, you may get 1 or 2 jurors that just can't get over it, but I think there's enough there for it to be guilty for sure. We have Ron Taharne says, I appreciate your enthusiasm in recreating the court drama. I even added in a little bit in there when there's not even drama in there. I sort of inserted in there myself because it's more interesting that way. But I'm glad you appreciate it, Ron. Thanks for being here. Another one from Pink Floyd says, thank you, Rob. Greatly appreciate these videos. Do you think the outcome of this trial is important to Durham's ability to prove FISA abuse? Seems like a warm-up for Durham's team to me. Well, look, if they don't get a conviction here, are they going to have the momentum, the energy, the desire to continue prosecutions? I'm not sure. I think they need to get a conviction if there's going to be enough momentum behind a continuation of the special counsel's office. Personally, we'll see. That was from Pink Floyd. Thank you for the dono. 63 Rambler says, why did you change your last name? How did that happen? So I am now Robert Gouveia. That's true. Earlier this year, I changed it. The way I explained it is I was mislabeled on the way out. A couple 30-something years ago, I came out, they slapped my biological father's name on there. And it's like, guys, that's the wrong label. Hello, I'm my mother's son. Her name is Marianne Gouveia. And so it's like, hey, there's a mislabeling thing that happens sometimes when you come out, and it's just not a big deal. Pretty easy. Just filled out a form, changed it officially. And so I changed it earlier this year, and I just actually had my final meeting with the judge. So you fill out a form, you got a judge, and then the judge schedules a hearing, then you go on there. Are you trying to get out of a felony, Robert Gouveia? Are you a Fed? No, I'm not any of those things. Can you please change it? And she changed it. And that's it. And so now I have got my mother's maiden name. And of course, I am certainly her son, and we have a very close relationship. And it just feels right. It feels better. So I made that change. I know it's a little bit harder to pronounce, and I know it's a little bit more confusing to type and share and remember, but that's just part of the deal. That's just how it goes. So that's what's happening. That's the story behind it. Thanks for asking about it, 63 Rambler. Kathy Wenzel's here says, I have watched since the Kyle Rittenhouse trial, and I find your style enjoyable. Well, thank you, Kathy. I appreciate that. I'm glad that you do. I have a lot of fun here, and sometimes I know it can probably be a little bit much, but I'm glad that you've been here. And that was a fun one. Kyle Rittenhouse, man, that was a fun one. I got a little emotional in my eyeballs thinking about that one. Conrad, and thank you for the dono. Conrad Roeder says, here's enough for another 10 pages. Thank you, Conrad. Thank you, Conrad. I know it feels like so painful. It's true. It's actually true. That's like enough for 10 pages, but it still feels painful. Oh yeah. Another one from Bill. Man, Bill, like every day with major transcript donos, says fantastic with 3 exclamation points. for Bill Meinhardt Jr. on the Transcript Dono Fund. Thank you very much, Bill. Frank Porillo with another Transcript Dono. Robert Barnes super chatted. It's Robert Barnes. I'm sure that's Robert Barnes. He says, transcripts pricey. And he posted that one up, which is true. And he knows. He's like, man, it's like, how much did you shell out on these transcripts? I'm sure he's probably wondering. A lot. It's a lot, no doubt. Robert Barnes is in the house. Robert Barnes, of course, you know Robert Barnes, don't you? Who doesn't know Robert Barnes? Robert Barnes is right next door on Locals. We're at watchingthewatchers.locals.com. They're right next door. vivabarneslaw.locals.com, I believe is what it is. And they're also right next door on YouTube. I mean, Barnes, you know, he's sort of, what's the word? Prolific, right? He's prolific, a very prolific man. And he's out there, you know, communicating all the time. But one of the best places to catch him is on Viva's channel, which is right next door here on YouTube. And I got to chat with Viva a little bit ago, a couple weeks ago. I went on there and we talked about Sussmann. And we might have to invite Robert Barnes on here to talk Sussmann. I'd love to get your take on that, Robert, if you're out there in the chat. But I'll reach out to you separately. But thank you for the Transcript Dono, because they are pricey, no doubt about that. John Kuna is here with the Transcript Dono. Thank you, John. No question on that one, but I do appreciate the support. And we're getting close to wrapping up here. Sargon the Later is here, says, Barnes believes this is a cover for the bigger fish. Cash Patel says this is a setup for others up top. Interesting. Yeah, and see, that's been part of the problem. I've been so focused on going through the transcripts that I actually haven't really talked to other people and seen sort of what a lot of other takes are. But now that we're done, we've got several days ahead while we can all sort of debrief and analyze this. I think it's a good time to talk with other people and sort of get their take on it and dissect a lot of this. And so if you have any suggestions on that, or if you know anybody else on YouTube who is covering some of this stuff, I think it's probably a good time to start, you know, set up an interview or sort of a group forum where we can talk and dissect through some of these things, because there's a lot that I missed. And you know, we read through almost every single page here, but not all of them. There were still a lot that we sort of flew through. And so certainly I missed a lot of it. I know that there's been some amazing reporting over from Technofog and some others, but you know, there's a lot to unpack, and as the jury is going to be doing themselves. So Sargon says that Barnes said cover for bigger fish. Very easily could be that. I could see that, no doubt about it. You know, you have a token prosecution and you just let the whole thing go, and everybody wants to see it go away. Durham doesn't want the FBI to, you know, have their noses rubbed in this anymore. You have the FBI covering up for their institution. The DOJ is covering for their butts. You know, Biden's covering for all the Hillary people. They're all plotting again on the upcoming election. So I don't doubt that at all. Look, and I've said this before. I've said this many times here, that these people are not going away, my friends, right? This is not the end of these people. Do you think Mark Elias is like, oh, I learned my lesson, I'm going to stop playing this game? No, he runs Democracy Docket. He's gearing up. Go on his Twitter right now. He's saying, we're going to join an Arizona lawsuit. We're going to file a motion to intervene and go and get back involved in all of these election litigation issues. So yeah, I mean, he might be sort of, you know, under the microscope a little bit for the foreseeable future, because everybody is aware of and educated about his tactics now. But the underlying efforts are all the same. They're not going anywhere. We know that, you know, all of these people are still rabid anti-Trumpers. They're still, you know, drooling Democrats. I mean, they're like feral almost, and they can't help themselves. Christopher Steele, Igor Danchenko, Rodney Jaffe, right? They're all out there still scurrying around the corners, which is why it's so important that I think we cover all of this and hold them to account. Cash Patel says, yeah, maybe this is a setup for others, and maybe this was just the tip of the spear, and then it just steamrolls from there. We'll see. Hopefully that is the case. We have Watts Mata says 2 weeks from now, the headline, Jim Baker didn't off himself. Awful. And also, in my humble opinion, the rebuttal today was devastating. It was good. I mean, I really do think it was good. I think that they delivered their arguments. He was pretty forceful, pretty aggressive, you know, used some colorful language. This is damning evidence. I've seen all sorts of cases. This is not even close. I agree with him. I don't think it's close at all. K Shaw also with a super chat dono. Thank you, K Shaw. No question on that one. But Jim Baker, hopefully Jim Baker's okay. The other guy I was really concerned about was Robbie Mook. Robbie Mook said Hillary okayed this whole thing. Robbie Mook's testimony was, no, she signed off on it. What do you mean? Hillary signed off on the approval of the Trump-Russia collusion story? Robbie Mook's like, yeah, she okayed it. She gave us the thumbs up. I was like, somebody better start Robbie's car for him. Where is he? Can he remote start that thing? Because it might explode into oblivion. I don't know. Hopefully they're all okay, but we'll see. But I think that, my friends, let me take a look at what we've got. That's it for the YouTube. Let me take a look at what's going on over on locals, because I know we got some chats going on over there. Got to do a quick refresh on the on the button. And we've got that here shouting out over to locals. JC, the music man, is Jeremy, says the events of this case are far worse than Watergate, and yet everyone has treated it like it's no big deal. It's like not even talked about. I was going to do it, but if you try to search for Sussmann, like Sussmann trial on YouTube, my channel, it like shows up all the way at the very bottom, all the way. It's like not even showing up in search. It's like so embarrassing. Why? Because they don't want you to know about it. They'd rather you watch Hollywood drama garbage, some of the most awful people that we've ever heard from, right? I was thinking about this the other day. I'm a criminal defense lawyer, okay? I've seen some pretty heinous things over the years. Some of the stuff that's come out in this Hollywood trial has been the most reprehensible, disgusting stuff I've ever heard. Honestly, like I've seen text messages from very angry people before. Not seen the language. I've not seen people excrementing themselves in other people's beds and stuff like that. This is like garbage. And there's like 1 million people watching it live every day. Okay, but whatever. I'm not mad about it though. Thomas Luce says, last dono for me for this trial. Sincere thanks for the great breakdowns. Well, look, Thomas Luce, that's totally fine. Honestly, I think we'll probably don't need any more donos at this point. I mean, there's not really going to be any more transcripts. There's going to be jury question transcripts and things like that. I've already confirmed with all the court clerks that there is, I want them. I'm like, yeah. She's like, do you want any more transcripts? I'm like, yes, all of them. She's like, oh, really? Yes, all of them, all the way through a verdict. Give me them all. She's like, okay, we're happy to do that. So they're going to keep coming in, but they're not going to be big, massive 100-page documents or 200-page documents. They'll be much shorter, a couple pages. And so I think, in other words, I can stop shilling for transcript dono requests, but I do appreciate them. Thank you, Thomas Luce, for wrapping that up for us. And I'm grateful that we were able to do this together. Vienticus here on YouTube says, I stumbled on this picture while looking for images of finches and I had to caption it. All right. So Vienticus has a photo here for us. Says, the Russian collusion stuff was proven to be lies, right? And then the other little birdie says, what? And I got to be honest with you, V, I've actually had this conversation with people. Okay. I have an attorney friend who would never watch this show. She's very, very liberal and left wing, but she's a great person. We're friendly, and she knows my politics, and she knows what I talk about here, and she knows the audience. And I've referred her cases and stuff like that from people saying they need issues that our firm doesn't help with, that her firm helps with. And it's just she's amazing, right? She wouldn't hold anybody's politics against them, but we are not of the same political disposition. And we went out to lunch one day, and we were talking. What are you working on? Or what are you working on? I tell her about this case, and she's like, well, what is that about? And I said, oh, it's about this whole Trump-Russia collusion hoax. Well, what is that? What do you mean? I said, remember Christopher Steele and the P tape and all these lies and all this? Yeah, it's all fake. I mean, he's been indicted for lying to the FBI. I've been covering the trial. The transcripts are out. I mean, many people acknowledge it's all fake. It's all a hoax. And she's like, what? Like, jaw dropped, absolutely just what? What do you mean? All of it. Yeah, it's all fake. So it's all fake. I mean, all those records, all of that conversation, it's totally fake. Yeah, but they said, I know what they said, but everybody's confirmed it. It's in the court documents. You can read it yourself. He's been indicted. He's going total shock. No idea what that was even about. And I suspect there are many, 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 many millions of people who would have that same feel because they were lied to. I mean, you talk about disinformation and free speech and making sure that information is protected. I mean, good Lord, what kind of disinformation was this? Sanctioned by Hillary Clinton, put out by the FBI and New York Times reporters and many people. Pure disinformation, all fake. What? Okay. And they were doing that. And, there may not be any consequences for it. So we'll see. Those were some good comments over from locals. We had a couple other, let's see, coming in from, they're chatting away over there. JC, the music man, is chatting along with Vienticus. What are they talking about? Okay, I can't read any of that stuff. But that's over. Miss Lucky's here. Hey, Miss Lucky is here. Miss Lucky and Sergeant Bob says, we've been following for the past 2 weeks. Miss Lucky and Sergeant Bob in the house. Tremendous also says, I wish I could be as optimistic as Rob. I'm not feeling good about this verdict. You could be right. Look, the defense attorney in me wants to sit here and say, yeah, you know, beyond a reasonable doubt, in my opinion, is a very high standard. It's very hard to prove. But, you know, juries they still convict. I mean, they convict a lot of the time, even if they're Democrats. We'll see what happens here. But Tremendous saying, well, you know, hang on. I was feeling that way too, Tremendous, until I read these closing arguments. I think they kind of tied it together nicely, put a little bow on top. And so we'll have to hang tight. But shout out to Miss Lucky and Sergeant Bob. I was thinking about you guys the other day, and I'm glad that you're here. Hope you're doing well. And I think that is it for us, my friends. Woo! We went through a full trial transcript, federal trial. You know, I think that's a thing. That's a thing that we did. We did it all together, and I really want to thank all of you. Robert Maxwell with another final transcript dono here. Very nice one. Says, I appreciate your work. Well, I appreciate you back, Robert Maxwell, and everybody here, seriously. You know, this was really a lot of fun. I wasn't sure how this was going to go. When we started the show, when I started this, I wasn't sure if anybody was going to be interested in this trial. I wasn't sure if anybody was going to support the transcript dono, if anybody was going to say, I want to watch this, and they would be willing to contribute to it. And so I took a little bit of a gamble. I said, I think we'll get enough interest. And I think I can do a decent job with this, that in a way that people will watch. And I think it worked out pretty well. And so I just want to say thank you. I mean, honestly, it was an experiment and I had a lot of fun doing it. I think that it is very important work, and I'm grateful to be a part of it. I just want to say thank you to everybody who supported the show, became a member, gave us these super chat donos. It really means the world to me. And I feel humbled that we're able to do this type of stuff together, because it is, I think, very important that we document it, and I'm happy to do it with you. But that's it for us for the day. Now, I'm going to try to set up some conversations with some other people to continue this conversation. So if you have anybody who you think would be worth speaking to, let me know in the comments or send me a DM on Twitter. I know many other people are talking about it, but my head has been so down in the transcripts that I haven't been able to come up for air. But over the weekend, I am certainly going to do that. And I would love to connect with anybody who you think would be worth talking to, including the one and only Robert Barnes. And we'll continue the content, and we'll start waiting for a verdict. In the meantime, there's a lot of other stories, and so we'll start to transition to some other topics as well. But not until we get that verdict will we actually leave this case. And so we'll be continuing to do it. And I hope that you join us on that journey. And so that is it for me, my friends. It is Friday night. I hope everybody has a tremendously amazing long weekend. You can expect some additional stuff out from me over the weekend and the long Memorial Day weekend. But I'm not sure exactly when or what, but certainly I will let you know. Otherwise, have a tremendous evening. I hope you all sleep very well. Have some times with your friend and family. Remember America and the reason why America is so great, all the people who supported the country. And that's it for me. So I will look forward to seeing you. Oh, let's do this one came in. Carrie Matchett says, 2 of them just came in. As I was glad I didn't hit the button. 63 Rambler says, you brought it to life. Well, thank you, 63. And like I said, it wouldn't be possible without you guys having some fun with me. And Carrie Matchett says, the other trial is about cultural manipulation through gender politics and a blow-up doll narcissist abuser being stopped. I don't even know. Look, I've heard the only clips that I've heard a couple clips on like TikTok and some of the other memes that are spread around on Twitter. I've poked in on a couple of the other law tubers streaming it and just sort of seeing what they're working on. But it's a lot. It's a lot to keep track of. And it just seems like it's some of the most toxic testimony, one of the most toxic trials that I think maybe has ever happened, which may be why it's so interesting to people. But, I mean, even what's the other one we've covered, like Derek Chauvin and Ghislaine Maxwell. I mean, we talked Ghislaine Maxwell here. And there's awful, horrendous stuff on there. Yeah, and but that was all federal, so we didn't get to see it. Like, it wasn't as in our faces, I suppose. I'm trying to think of, like, how do you distinguish that from the Hollywood trial? And Hollywood is really, it's live, right? You can see it, you can hear it, you can hear the language. It's like dripping with disdain from these people. Everybody in that courtroom just hates each other. I mean, it's It's really a spectacle. It sort of reminds me of something like the Roman Colosseum to some degree. You know, the idea would be back in the Roman era, you put a bunch of people in a Colosseum and you just throw a bunch of people down there on the field and you just let them kill each other. And everybody's just loving it. Ah! Kind of feels like that to me. You know, it's like, that's a little bit, I'm not interested in that. So, but I know other people are, and I'm really trying not to throw too much shade on it, but that one's done too, which is good. That means there'll be more oxygen in the room for some of the other more important things that are happening. And then we can kind of get back to some normalcy, I think, as these trials come to conclusions. But thank you again for the support. That's from Carrie, 63 Rambler, Robert Maxwell again with those last super chats coming in. And so that, my friends, is now it for me. I want to thank you so much for being here. It really has been a lot of fun covering this trial. Really grateful for all the support. And we're going to continue to do it. We're just going to wait for the next one. We're going to finish this one out. There's a lot more work to do. And I'm grateful for you being here and joining us as we continue to do it. And I am now going to leave you at that one, but have a tremendous evening. Spend some time with some friends or family. Unplug from some of these politics a little bit. It's Memorial Day. There's a lot of good reasons and good things to celebrate over these 3 holiday weekends. And so I hope you do enjoy it. That is it for me, my friends. Have a tremendous evening, and I look forward to seeing you very soon. Bye-bye, my friends. Bye.